I'm praying for listing of 4 numbers of registration.
Motion.
Admission logic matters are pertaining to completion appointment logic on similar serious matters have been taken part of the application.
Okay.
Not to pray for listing for matter in the orders column. Any day next week.
Go to the registry.
Not to be prayed with the application the registry 2-3 times, but not.
No, you see, they I think, how did you submit your application? By written application? Huh? Did you fill up a form?
No, not form.
I think there is a form to fill up.
Not application.
They've got a form there, you fill it up. Otherwise, you see, the problem is some matters which are very old are not being listed because only the ones that are being mentioned, they are being listed time and again, leaving out those ones which are there for number of years. So they are doing that, ensuring that everyone gets some court time.
I would like to mention item number 10, worksheet.
Item 10, yes.
Regarding compassionate appointment. This matter may be tagged with serious matter class.
No. We'll see. Do it. Let the council come. Let the council come.
Please select it.
Yes.
Check with the consent of the other side.
Huh?
With the consent of the other side, affecting item number
25.
check in this matter were yet to file a affidavit. Worship my kind fee by first 3 weeks.
To file affidavit in position. Who's for the petitioner? Item 24.
25.
25.
Petitioner.
Have you spoken to the petitioner, madam?
Worship was taken sometimes last week.
Okay, Miss
Be sure him.
V.
Sure.
How do you spell? You write it down. Appearing on behalf of
The J. Chutia. Worship.
Mr.
J. Chutia.
J.
Chutia Lodge.
Chutia. J.
Standing counsel. Hey.
J. Chutia. The standing counsel for the KAC is granted
3 weeks.
3 weeks time to file affidavit in opposition. Who is appearing for the elementary? Are you filing anything in item 25? Huh? So nothing to do with it. Mr. B. Kaushik, appearing for the elementary education department, submits that he has got no, submits that the elementary education department does not have any comments to make in this case. Yes. Where is that DO?
Connected to that.
He is connected. So,
Yes.
so the petitioner retired when?
30, 11, 12, 16.
Huh?
30, 11, 12.
13, 11, 16. Achha, this is from whom?
Malapur DO Hailakati. Document, if the first portion will also will come to the last. The paragraph on receipt. On receipt. The paragraph from on receipt.
Paragraph 5.
Paragraph 5.
It says on the basis.
No, let us read from the starting of the paragraph. Accordingly, the petitioner has been drawing
Yeah.
pay at so-and-so with effect from 1/1/1985 onward. The petitioner retired on 30/11/2016 and his last basic pay was so-and-so as on 30/11/2016. On the basis of his last basic pay drawn by the then DO, Hailakandi has sanctioned and released provisional pension with effect from 1/12/2016 and provisional DCRG amount of rupees so-and-so and released by DO by order dated 20/09/2017. And then his pension paper and original service book has submitted to the Director of Pension by letter dated 20/02/2018. On receipt pension papers of the petitioner, the Director of Pension Assam has raised following objection. Excess payment be assessed if the excess payment is not due to the misrepresentation on the part of the petitioner. Head of the office department may waive the recovery with the approval of the finance department. On receipt of the above objection, the DEO Hailakandi has made the objections after assessed and excess royal as per the record correct pay as entitled as per rule and resubmit the pension proposal and original service book dated on 29/06/2019.
Let us see the letter initiative.
Hello.
Where is this initiative?
Annexed the
12/11/21.
page 18.
The last.
Resubmission of the pension papers and original service book of Nazmul Hussain, retired headmaster, so and so.
So there was excess payment of 7 lakh.
Yes.
Huh?
So from the DOs and the proposal has already been submitted from the to the Director of Pension.
Okay. Subsequently, the Director of Pension has finalized the pension of the petitioner by PPO number so and so by deducting excess dollar amount from the monthly pension and also from the DCRG. Now the parent has been drawing his monthly pension regularly. It says that you are drawing a monthly pension regularly. Now the grievance of the petitioner is that the director when enough monthly pension. Okay. No.
The grievance is that the petitioner wants the refund of that excess
So
deducted by the Director of Pension.
so you have to change your writ petition. You see, what has happened is the excess doll of 7 lakh something that has been deducted from your pension and from your pension and from your DCRG amount. You can take this letter. We'll give you this letter. Hey, yes, Mr. Big Kaushik, give him a copy. It's okay if it's not there. His thing is there. Here. Okay. Okay. No problem. No problem. Since so this yeah. So Mr. DEO, can
Yes,
you hear
sir.
me?
Yes. Yes, sir.
Acha, okay, now we have got we know now the issue. Only thing is that it
Yes.
appears that you have not given any letter to the petitioner regarding
Okay.
the fact that the excess drawl of pay of rupees 7 lakhs or so
Yes,
has
sir.
been deducted from his pension and DCRG. That you have not given to the petitioner.
Okay,
That
sir.
is why this writ petition has been filed
Okay,
on
sir.
the ground that pension has been wrongly calculated. So I
Okay,
think
sir. I will.
so you can furnish a copy of those documents to the petitioner. Okay?
Okay, sir. I will furnish it earlier.
Yes, everything. I will
Okay,
give
sir.
this copy also. Okay,
Okay.
thank you. Okay. So basically, you can take this,
I'll give her.
you give her a copy. And we'll close this writ petition because your writ petition is on a different thing. Now from here it shows that you have taken excess pay of 7 lakh something. And they have deducted that amount from your pension and DCRG. So for that you'll have to make a separate challenge. Okay? It's okay, madam? Huh?
With the liberty, my lord, file a fresh petition.
No need to, okay, okay, you want to withdraw? Okay. Wait, instead of withdraw, okay, but I'll have to mention everything.
You also will indicate.
I'll have to indicate everything. Right, Miss
Yalwadi.
Huh?
Yalwadi.
Wahida,
Wahida.
Wajida, learned counsel for the petitioner, and Mr. B. Kaushik, learned counsel for the elementary education department.
And some
Who appears? Anybody else?
government has put nobody.
Miss
DD form.
DD Bond.
Eddie Burman,
DD Burman.
Mr.
And MS DD Burman.
MS
DD Burman, additional senior government.
appears on behalf of
Response number 4. Director.
or anybody else?
No.
No. Okay, right. You think this last order, second paragraph? Then, right? The petitioner's case is that he had retired on attaining the age of superannuation on 30/11/2016. And despite a lapse of more than 9 years, the wrong fixation of the petitioner's salary and pension and other retirement benefits had not been made by the state respondent. The DEO Hailakandi has submitted letter number DEH/March/2025/1257 dated 27/3/2025, which is addressed to the Director Elementary Education, which is to the effect that there was an excess drawal of pay amounting to rupees 7,34,363. No, look at it. There's an excess drawal of pay which had been adjusted by deducting the excess salary paid from the monthly pension and from the DCRG amount payable to the petitioner. The DEO Hailakandi has also submitted letter dated 12/11/2021 issued to the Director of Pension, wherein it states that there had been excess drawal of salary amounting to rupees 7,34,363. And it appeared that there was no fault or misrepresentation on the part of the petitioner for drawing while drawing such excess amount. Next paragraph. Ms. So-and-so, another counsel for the petitioner submit that in view of the letters dated 27/3/2025 and 12/11/2021 issued by the DEO Hailakandi he would like to withdraw the writ petition with liberty to file afresh. To allow the petitioner to make a challenge to the deduction of the excess salary paid to the petitioner from his monthly pension and DCR. The prayer of the petitioner's counsel is allowed. The writ petition is dismissed as withdrawn, with liberty as paid.
I've given
The letter dated 27/3/2025, along with other annexures, including the letter dated 12/11/2021, issued by the DEO Hailakand, are made a part of the record and marked as annexure X collectively.
the same is also furnished with petition. I've given
Ms. So-and-so submits that the documents referred, that the annexure X, a copy of annexure X has been furnished to her just now.
Personal appearance may be
The personal appearance of the DEO Hailakand is dispensed.
Lordship, the order is at page 12, Lordship. The operative part starts from paragraph 36, Lordship, page 27.
Okay, heard Ms. S. Das, learned counsel for the petitioner, who submit that the order dated 6/9/2024, passed in WPC 6962 of 2021, has not been complied with. No, just submit that the payment of gratuity and other service benefits in terms of the order dated has not been complied. Issue notice returnable in 4 weeks. Petitioner will take steps for service of notice upon the respondent by registered proceeding within 3 days. List the matter after 4 weeks.
Okay, Lordship.
Mr. P. Bardwaj, then counsel for the petitioner, submits that the respondent has not verified the incremental dues payable to the petitioner in terms of the order dated 4/3/24, passed in WPC 7108 of 2021. Same, huh, sir? 3 days. Item 3, the writ petition number is 6752 of 2022. Otherwise, everything is fixed. Okay. This has wrongly come in the motion column. Notice has already issued. Yes.
Instruction is awaited.
Huh?
Instruction is awaited.
Okay, right. Mr. R. Ronghan, learned counsel for the KAC, paid for further time to obtain instructions and file affidavit. A further 4 weeks time is provided to the respondent at KAC to file their affidavit. This is the matter of the court. The registry to list this matter in the admission column. In as much as notice has already been issued on 5/2/2025. No, 2025 matter.
Last order,
Item?
As per last order, your lordship, updated instructions were called for in the respondent 1 to 3.
Your Lordship, as per telephonic instruction, they are preparing it, Your Lordship. Kindly grant us 1 week time, Your Lordship. Pardon. By Tuesday.
Okay. Ms. P. Das, learned counsel for the respondents number 1 to 3, submits that the updated fresh proposal for arrear pay is being prepared and the same will be ready by Tuesday. Accordingly, list this matter on 2nd. 2nd is Wednesday. If Tuesday is declared No, no, it's first.
Tuesday is second.
No,
Tuesday is first,
Tuesday is first.
Wednesday is second,
Tuesday might be declared. Huh? Might be declared.
Wednesday. DPO.
Obligation. Yeah, please, Lord. Yeah, please, Lord. This case, my service was provincialized. That was challenged. And subsequently, order was passed, asking the respondent herein to file a appeal. He did not turn up. He even did not attend the school also. Now my position is in hanging man. So I have come.
No, no, let's come to the order.
The fourth.
838.
Yes. The implementing
Yes,
part is,
please read, please read.
under the implementing part is at page number 38.
Correct. Please read.
Under the petitioner was appointed as an assistant teacher in Assam.
No, no, not that. Accordingly.
The paragraph number second last, my lord.
Yes,
Accordingly,
yes. Third paragraph, yes.
accordingly, the petitioner is directed to file an appeal before the State Scrutiny Committee within a period of 2 weeks from today. The State Scrutiny Committee, on receipt of the appeal from the petitioner, shall consider the same after hearing the parties as well as the petitioner as well as the respondent number 7 in person, and thereafter shall pass an appropriate order in accordance with law within a period of 2 months from the date of receipt of the appeal. The interim order dated 18/8/2021 passed by this court shall continue till appeal is disposed of by the State Scrutiny Committee.
Correct.
That is
So,
clear.
so, Mr. Counsel, now this order has been passed by a court, by a coordinate bench.
Yes.
Now, I cannot change this order.
Yes.
You have to file either a review or file an application before that particular court. You have to file an application. You cannot file a fresh writ petition.
I filed a mistake, my lord. That was, the review has to be filed, my lord. That cause of action arose subsequently, my lord.
Huh?
The cause of action arose subsequently because I got now the information that no appeal has been filed after.
Correct, correct. That is why you have to ask for clarification of that order from that court. Because that court, the coordinate bench has held that the respondent herein will file an appeal, and till that appeal is decided,
Yes.
that thing will be stayed. Unfortunately, he has not filed an appeal and you are getting stuck
Yes.
up. Now, so you'll have to tell the court that please modify this order to the effect that unless the appeal is filed within a particular date and decided within a particular date, the stay order cannot be in perpetuity. So you have to go to that particular court. Now, how can I pass?
Then, in
There's a
the
different-
of my lord, this matter was placed before that court.
No, 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 no. This is a different writ petition. You have to file either a miscase or a review before that court, not a writ petition. I can indicate.
I'll pass a mistake.
You file a miscase before that
Miscase,
court.
yes.
Yes. I can give a slight indication also if you. Right.
Yes.
Heard, Mr.
MK Mishra.
M.K. Mishra, learned counsel for the petitioner, who submits that in terms of the order dated 6/2/23, passed in WPC 3847/2021, the respondent number 7, is it? Respondent number?
In the present case, not the respondent number.
This is what? Respondent number 5. The respondent number 5, comma, who, bracket, you write, who was the petitioner in WPC 3847/2021, huh? Had been directed to file an appeal before the State Scrutiny Committee within a period of 2 weeks. Full stop. Thereafter, the State Scrutiny Committee was to consider the said appeal and pass an appropriate order after hearing the parties. Till the appeal was disposed of, the interim order dated 18/8/2021 passed in WPC 3847/2021 was to continue. Next para. The petitioner's counsel submit that till date, the respondent number 5, bracket, who was the petitioner in WPC 3847 of 2021, bracket 4, has not filed an appeal before the State Scrutiny Committee. As such, the interim order dated 18/8/2021, passed in WPC 3847 of 2021, is still continuing. He submits that for no fault of the writ petitioner hearing, the interim order is continuing due to the inaction of the respondent number 5. Next paragraph. On considering the above, this court is of the view that the petitioner should either approach the should approach the concerned court which had passed the order dated 6/2/2023 in WPC 3847/2021 for a clarification. No, by way of a misapplication or a review for clarification of the said order dated 6/2/2020. Keeping in view the facts that has been raised here, the issue that has been raised here. Ms. N.J. and Fukan, learned counsel for
Respondent 1, 3 and 4.
1, 3 and 4. And Ms. R.M. Barwa, learned counsel for the point number 2. Also submit that the petitioner should approach the concerned court which passed the order. At this stage, the petitioner's counsel submits that he may be allowed to withdraw the writ petition.
If never maybe it continues, I will file a mistake in the.
No, I'm not going to allow. Where's the question? You want me, I'll dismiss it. There's no problem.
I don't.
At this stage, the counsel for the petitioner, I've given an indication already. At this stage, the petitioner's counsel submits that he may be allowed to withdraw the writ petition with liberty to approach the appropriate with the concerned coordinator. The pair of the petitioner's counsel is allowed. The petition dismissed as withdrawn, come out with liberty. I think that's the correct way, I think. Otherwise, how can I change that order? Otherwise you can file an appeal. You put or file an appeal, huh?
It is related to the election of college. When the election was done,
They are challenging the selection of the respondent number 6.
yes, sir. So, my prayer is I have filed 3 representatives. No, finally, all will be taken by the director or that may be disposed of the justice. Otherwise, also, Lordship, at this moment, it is premature in terms of. I admit that. I rules and regulations. I consider this. But it is the.
Why? The selection has not been
No, the approval is not given. That is. Approval till date panel is not
Then-
given. That is why
then-
the right has not been active.
There's no right. How can you come in between?
Our approval is also. But I am clearly decided. But I have a lordship in the earlier occasion also passed an order.
Maybe, but always it doesn't. Otherwise, it will never end.
Paragraph 4, Lordship, is the rules and regulations of.
Paragraph 4.
Paragraph 4 is the rules and regulations. Okay.
Yes.
May I read?
Yes.
Paragraph Rule 7, the rule 5, it says first method of petition. Then selection body will have to proceed. They will have
Which
to.
paragraph?
Paragraph 4.
4. Yes.
Yes, may I read?
Yes.
It is stated, and it is stated in the part that the recommendations made by the governing body of so-and-so college Dibrugarh for the post in question in pursuance of the selection held has not been considered by the Director Higher Education Department under the provisions of the Assam College Employees Provincialization Act 2005 and the Assam College Employees Provincialization Rule 2010 on account of tendency of present proceeding. The relevant provisions of Rule 2010 as quoted herein below. Township Rule 5. Method of recruitment. Recruitment shall be made in the manner prescribed herein. One, appointment to the post of principal shall be, here lordship, two is really bad. Type two, clause two. For the post of lecturer, librarian appointments shall be made by the direct recruitment with prescribed qualifications through open advertisement in two leading daily, at least in two consecutive issues. In respect of grade 3 and grade 4 posts, the list of eligible candidates shall be collected from the local employment act advertisement so and so. Then lordship rule 7 below direct recruitment. It says that all appointment either by direct recruitment or promotion shall be made by the director on the basis of the recommendations of the governing body based on the recommendations of the selection committee, department, the promotion committee duly constituted. So lordship, after the selection committee forwards it, then director has to give his opinion. Then lordship, the paragraph that has been discussed in paragraph 6.
Yes.
Having noticed the scheme of selection for the post of principal or auxiliary assistant professor in a provincialized college, that what is admitted in the present case is that the selection process has not yet attained finality. It is only when director accords approval to the recommendation of the governing body that the selection could attain finality. This aspect of the matter was gone into by the court in the case of Sonali Bora Sohoria versus State of Assam reported in so and so. And it was held that until the director grants approval to the selection process, no final decision can be said to have been taken in respect of selection. No definite cause of action. No definite cause of action can be said to have accrued at such a stage to float an unrecommended candidate as aggrieved party, thereby enabling him to initiate a legal action. Selection by selection committee or recommendation by the governing body per se would not give rise to cause of action for initiating a legal proceeding because no finality is attached to such recommendation at a stage prior to acceptance and not by the government. So the reading has been clearly stated. So this is also a case of I am my not disagree with this. So my not fair is this. The selection committee already my not recommended by illegally allotting my not 1.5 marks to the response number 6, which is not entitlement. This is my case. So my prayer is not a big prayer. My not is only the simple prayer. Okay, representation this is 5, 8, and 10. That I have already submitted through online as well as a hard copy also. But the director is not taken any call on that. That is why I fear that at least the director should take a call on this issue. After all, whatever is there, but I will be accepting it. No problem. But I am not challenging the appointment of any position.
So out here also, the director has been asked to consider both.
That may be done.
So
Paragraph.
So let him be. Let him.
Yes.
So let the director hear him out.
Yeah, direction is there. Paragraph 9.
Right. Heard Mr. P. Mahanta, learned counsel for the petitioner, who submits that the petitioner took part in the selection process for filling up the vacant post of assistant professor (philosophy) at Puthi Murray College, Soneshwar, Kamrup, Assam, pursuant to the advertisement dated 26/9/2022. Though the petitioner was expecting to be selected, the selection committee has recommended, selected and recommended the name of the respondent number 6 as the first nominee, followed by the petition for the post of assistant professor of philosophy. Bracket 19 unreserved. Bracket close. The petitioner's counsel submits that the petitioner is agreed by the granting of marks.
1.5 marks.
Granting of 1.5 marks to the
Question number 6.
to the respondent number 6. To the respondent number 6. And in this regard, the petitioner submitted representations dated 5/3/25, 8/3/25, and 10/3/25 to the respondent number 2. However, no decision has been taken by the respondent number 2. Next one. Mr. A. Tabildar,
A.R.
A.R. Tabildar, learned counsel for the
On and rest on higher education department.
for the higher education department. On the other hand, submits that the selection process has not attained finality as on date in terms of the Assam colleges employees bracket provincialization bracket close Act 2005 and the Assam College Employees bracket provincialization rules 2010. He submits that the recommendation / selection made by the selection committee is to be forwarded to the director, who is to thereafter issue the appointment order based on the recommendations of the governing body and selection committee. Governing body has decided.
Selection committee, then governing, director will examine the. Correct.
Selection committee and governing body is different.
Governing body constitutes the selection.
So whatever the selection committee decides is approved by the
It forward to the director.
is approved by the governing body. Then.
Yes, approved by the government.
He submits that in a similar case, that is WPC 1130/2015, Dr. Gita Moni Andik Gogoi versus the state of Assam and 4 others, which was disposed of on 7th of 2020. The grievance of the petitioner therein against the selection of the respondent number 5 therein was directed to be decided by the director, higher education department. He submits that a similar order can be passed here. I have heard the learned pass for the past. On perusing the order dated 7/12/2023, passed in WPC 1130/2003. And the facts of this case, I find that the facts are quite similar. It is clear that no final appointment order has been issued by the director, thereby implying that the selection process has not attained finality. However, as Rule 7 of the, is it Rule 7 or Section 7?
Rule 7.
Rule 7 of the Assam College Employees Provincialization Rules 2010 provides that all appointments shall be made by the director on the basis of the recommendations of the governing body, based on the recommendations of the selection committee. It would be proper if the director or higher education department takes a decision on the petitioner's representation. Which representation?
Well, this is annexed 4, 5, and 6.
All of them. Petitioner's representation they discuss
5, 3, then 8,
within before issuing. Now, while considering the recommendation and selection of the respondent number 5, 6 by the selection committee, that governing body. Governing body has not decided. No.
Governing body, and they only
Governing body, that governing body, yeah. The writ petition is accordingly disposed. That's all. Right. What is your case?
My lord, the matter relates to provincialization, my lord. In a upper primary school, my provincialization is now attempted to be interfered with. my lord, pursuant to an order passed by this honorable court, my lord, the appellate authority take up the case and pass a direction that to re-examine the whole sub-pattern of the school. Now, what the district scrutiny committee of
Let
the
us see what is the order passed by this court.
my lord, may be pleased to find the order, my lord, is at page 47, my lord.
47.
My-
You are,
I
where is
am,
your name?
my lord, in this, I am, my lord, in this petition is respondent number 6, my lord.
You are respondent number 6.
My lord.
And the Shah Jahan Ali Mandal
He
is
in my petition now he is respondent number 7.
respondent number 7.
My lord.
So then what is this court said?
My lord. Now, my lord, if my lord may be pleased to peruse the last part, my lord.
Yes.
Paragraph, my lord, the last paragraph, the learned counsel for the parties are in agreement that the writ petition can be closed with a direction to the appellate authority to dispose of the appeal after hearing all affected parties, including the respondent number 6, my lord. Upon hearing the learned counsel for the parties, this court is of the view that the end of justice will be met if a direction is issued to the secretary to the government of Assam Department of School Education Elementary so and so to effectively dispose of the appeal filed on so and so preferred by the petitioner under section 14 of the so and so Act of 2017 by passing a speaking order. The appellate authority is directed to dispose of the appeal within a period of 60 days from the date of receipt of a certified copy of this order. Any such order that is passed by the appellate authority, copy thereof shall be served upon the petitioner. The writ petition is accordingly closed in terms. Now, my lord.
So this was, so the writ petition had been filed
My lord.
because the writ petitioner therein was agreed by the recommendation made
Recommendation as well as my provincialization.
provisional order issued.
I have already been provincialized. I am getting the benefit also, my lord.
Provincialization order issued when?
Yes, my lord. It is on 5/2/2021. My lord may be pleased to find
5/2/2021.
my lord at page 49.
Then why is it out here? It says, come to page 46.
No, my lord, we have not annexed the provincialization order.
No, without no.
It is admitted, my lord.
Where it's not admitted, you come to page 46. Come to page 46.
Yes, my lord.
Please read the second paragraph.
The writ petition is filed by the petitioner being agreed by the recommendation of the district scrutiny committee recommending the respondent number 6. That is correct, my lord.
When is the provincialization?
No,
This
no.
order is passed in 23.
23, my
When
lord.
you said that you are provincialized in 21, how can it be?
My lord, that order I have not annexed in.
You have not annexed because then you should have clarified here. And everything is done as per your consent. There is no provincialization as on 23.
No, my lord, what they have done, my lord, it is not my writ petition, my lord.
Maybe,
Because they-
but you are a party.
No,
You are respondent number
party,
6.
No, I am a party, my lord. I have not disputed to take up the appeal by the appellate authority. Let the appellate authority examine what was there. It can be examined by the appellate authority, my lord. Now, the appellate authority has, my lord, responded to the direction, my lord, passed by this honorable court, my lord, and arrived at a decision, my lord, is at page 49. Just for a moment, I beg to draw my lordship's attention to page 49, annexure 11, my lord. The decision part, my lord. In view of the above facts and circumstances, it is observed that the DSC Gwalpara recommended 3 teachers of the future under the clause so and so of the service. The respondent number 6, present petitioner, my lord, has been recommended by the then DSC Gwalpara as a social studies teacher tutor for provincialization. However, so and so himself has stated in the affidavit that he has submitted the particulars of so and so wherein his name was indicated as subject, Assamese language, and against the name of the writ petitioner, subject to the social studies and against the name of MD social studies teacher of the tutor. As such, the DSC Gwalpara is
No, no, but the
Mal-
DLC.
my lord, sorry, my lord, I have
You're
the
selective
DSC,
amnesia.
recommended the Sohidur Rahman as social studies teacher of the tutor. As such, the DSC Gwalpara is directed to examine and review the proposal for recommendation of services of teaching staff as per the Assam so and so Services Act of 2017 against the KB Memorial and so submit to report SLC immediately. Now, my lord, what is the direction of the appellate authority is that the entire staff pattern, my lord, who were recommended earlier, is required to be re-verified, re-examined. Now, my lord, what the authorities has done. at
No,
6:50,
wait.
My lord.
There's no point. As
Provincialization order, clearly.
Where have you said in your writ petition that you have been provincialized?
My lord, in paragraph 9, my lord, in this.
Paragraph 9.
My lord. Page 10, my lord, kindly have a look, my lord. That hereafter-
Individual order of provincialization was issued by in
My
favor of the petitioner.
My-
Where is this provincialization order?
Lord, no. That, my lord, I have not annexed here, but I can produce, my lord. I can produce, short date may kindly be given, my lord, by Monday I will produce. Huh? Or, my lord, after some time.
Wait.
My-
Yes, you can produce it on Monday.
My lord.
You can come here, but I'm not coming on Monday.
Oh, my lord, I am sorry, my lord. My lord, on Wednesday, my lord, coming Wednesday.
Right.
Assembly.
Heard Mr. A.R. Buyan, learned counsel for the petitioner, who praised that
My
the impugned resolution number 2 dated 23/24 July 2027, adopted by the DLSC Golpara Assam in its meeting dated 23/7/24 should be set aside,
My
along with the impugned letter dated 5/11/2024 issued by the DEO Golpara. Where is this impugned resolution?
My lord, the resolution, my lord, may be pleased to find. I have not annexed, but it is a part of the, my lord.
You have not annexed and you are challenging and you are asking you to set aside.
My lord, this is the
What
order.
kind of a writ petition is this?
No, my lord, the impugned resolution, my lord, which has not been provided to us, my lord. And but.
Where have you said that it has not been provided to you?
But, my lord, it is.
No, let me see. Where have you said in your writ petition that it has not been provided to you?
Yes, my lord, that statement we have given, my lord. My lord, it is in the speaking.
Let me see. I don't want the speaking order. I want your, because you have not, you are asking for setting aside of an,
Without an.
yes, without annexing it. What is this? What kind of a writ petition is this?
My lord, we have got the provincialization order.
Maybe you file affidavit.
That is clear.
You will have to find everything. You see, you have to find everything. You cannot do things in bits and pieces.
No, my lord. My lord, sometime, my lord.
You see, when,
My lord,
because I'm going to record everything. I'm going to record what the court has said in the earlier judgment.
My lord, page
So
15.
it gives, why didn't you tell the court earlier that your service was provincialized?
No, my lord, as the, my lord, appellate authority.
I don't know.
My lord, in page 15, my
Okay,
lord.
right. Anyway,
Page
carry on.
15, my lord.
Okay, no, leaving that aside. Now, where is this impugned letter dated 5/11/24?
It is in the last page, my lord. No, 5/11. Page 50, my lord.
50.
My lord, 50. The date is below, my lord, 5/11/2024.
Next, you write. Though the petitioner has prayed for setting aside the resolution number 2 dated 23/7/2024, adopted by the DLSC Golpara Assam in its meeting dated 23/7/24. The same has not been annexed to the writ petition.
But we have made statement, my lord.
You may make anything. Next paragraph. The letter dated 5/11/2024, which has also been put to challenge. Page as follows. Page 50. Yes, sir. The petitioner's counsel submits has further submitted that the petitioner's service was provincialized as
Milord, as tutor.
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 Show me.
One. Other, it is not very legible.
No, it's okay. Whatever. I'll have to do with whatever you have.
We'll track it out, Milord.
The petitioner's counsel submits that the petitioner's service had been provincialized as tutor. Tutor. What is this name of recognized UPS? What is UPS?
Upper primary school, Milord.
Name of base school is Arabanda. So you were teaching where?
Milord, Arabanda school.
Teaching in Arabanda LP school.
My lord, now it is.
Where have I said?
My lord.
Tutor. In Arabanda LP school. Bracket name of base school, name of it. Provide order number EPD-16/PROVN-UP/ACT 2017 bracket close /2021/2785 dated 5/2/2021. Wherein his fixed salary was wherein he was to receive fixed salary of rupees 10,800. Okay. Next para. The petitioner has prayed for setting aside the impugned resolution number 2 dated 23/7/2024 and the impugned letter dated 5/11/2024, which has been made on the basis of the order dated 14/8/2023 passed in WPC 4047/2023. Next paragraph. In WPC 4047/2023, the petitioner herein was the respondent number 6. And the respondent number 6 in this case was the writ petitioner in WPC 4047/2020. Next paragraph. This court, while disposing of WPC 4047/2023. Filed order dated 14/8/2023. Stated that the respondent number 6 hearing had been agreed with the recommendation of the District Scrutiny Committee, recommending the respondent number 6, recommending the writ petitioner hearing for provincialization in the subject of social studies in respect of KB Memorial ME Madrasa in the district of Golpara, which had apparently been amalgamated. Is it?
Yes.
No, don't say that. So you were basically you were not in Arabanda LP
I
school,
am
you were in KB Memorial.
Both the schools were later and amalgamated. My
Don't say
appointment
that which had been amalgamated.
agreement. My instruction is that, my lord, initially the petitioner was appointed in the KP Memorial by appointment order in the page 27. Now, during the course of provincialization, my lord, both the school got amalgamated and Arabinda is in existence and the KB Memorial is now not more in existence.
Correct.
Well,
Okay.
that is the factual position.
But that is what is stated there.
Well,
Full stop. Next. KB Madrasa, which had apparently been amalgamated subsequently with Arabanda LP. When was it amalgamated?
Lord, during the course of provincialization.
The petitioners council will have to clarify the date on which KB Memorial ME Madrasa had been amalgamated with Arabanda LP. Next para. The order dated 14/8/2023 passed in WPC 4047/2023. All had disposed now. The order dated 14/8/2023 had disposed of WPC 4047/2023 as follows. Okay. As follows. You take it from page 47 from here to here. Okay. Next. A perusal of the above order dated 14/8/23 passed in WPC 4047/20 clearly goes to show that at the clearly goes to show that at the time the order was passed, neither had the writ petitioner hearing been provincialized, nor had the, this point number 6. However, the petitioner has now taken a different stand altogether. So, on the prayer of Mr. A.R. Bhuyan, learned counsel for the petitioner, who submits that he will produce the,
Lord,
he will submit the,
Lord, one thing may I submit? I'm sorry, interrupting, but the petition has been disposed of at the motion stage, Lord, and we were not present, Lord.
that's why I'm going to call the record.
Fine. Fine.
Anyway, if that was there, you can go in appeal. Why? I cannot pass a different order than what the coordinate bench has passed. I'm not the appellate authority or the reviewing authority.
My Lord can examine the record.
I can examine, but I cannot change the order.
No, my Lord, we are not, I am not praying for changing of the order also. But whether the order has been followed by the department in.
No, I am on the question of, you see, you have said it is nobody's case in that order that you had been provincialized. Nobody's case. If you found that the contents of the order passed by the coordinate bench was wrong, you could have gone to the division bench, saying that this wrong order. You could have gone in review, saying that this is a wrong order. Your facts are wrong.
That's correct.
I cannot do that anyway. On the prayer of Mr. A.R. Bhuyan, learned counsel for the petition, who submits that he will produce the impugned resolution number 2 dated 23/7/2024 on second. On second.
My Lord, then
Ah,
some more time.
Release the matter. Huh?
Some more time may be given.
On fourth. On fourth. Okay, on third. On third. List the matter on third. Good stuff. Registry to place this case along with WPC number 4407 of 2020, 4047 of 2023, which had been disposed of by order dated 14/8/2020. 4047 of 2023, disposed of on 14/8/2020.
Lord, may I have a small submission? Lord, we have tried our best, Lord, for the impugned resolution. My learned friend.
Are they impugned?
Impugned resolution, Lord, which my lordship has asked.
I don't know. That's what you said. You have it. You produced.
No, my Lord, we have tried, but we could not get the same, my Lord. If my learned friend, my Lord, can.
I do not know. We'll see on that day.
Fine.
Nothing new. I'm not.
Oblige.
Petition challenging this memorandum.
Huh?
Petitioner is challenging the memorandum.
Where's the question of challenging? You have got no right to challenge. Unless your DLC order rejecting your application is set aside, you have got no right to challenge that 18/9/2024. You have got to, yes, come, please come. Where is your right to challenge the 18/9/24 OM? Unless your DLC order is set aside, there is no ground to challenge 18/9/24.
But one make it that, but I have understood, but item number 1 in the series, but it's the same case, similar matter. So therefore,
No, I'm going to clarify all that. Those things I'll clarify when I'm disposing of. So no point.
once my lord, the compassionate department will be revived, then my right will be revived. Because now my lord.
Correct. Only when only when the DLC rejection order is set aside,
Yes, sir.
then only your right to challenge that 18/9/24 comes.
Therefore, my
You
lord,
cannot build your second floor without the first floor.
yes, sir. Therefore, my lord, I have put both the prayer.
No,
To
both
set
the,
aside and my lord for the.
no. How?
But you can
How can,
my
we
prayer.
can, then we have to first decide the first prayer. There's no question. There's no question of the second prayer. Unless the first prayer is allowed, there's no question.
First prayer is setting aside the matter of memorandum.
That cannot be done.
But one thing is that I'm understood, my lord. Lordship, my lord, in the series matter, last item is similar matter.
Maybe, but then that's what.
Lordship, in the future of the matter, my lord, that matter, my lord.
You tell me. That now that issue. Now let us see the DLC recommendation.
TLC, my lord,
DLC rejection. Let us see.
Page 64.
64.
Or my lord, may come on after 1 month.
No. Nothing doing. Page 64.
Page 64.
Uh,
Serial number 4. The proposal of N. Vijit Kumar Sinha was considered in the meeting held by the DLC as per direction of the Honorable Guwahati High Court status so in WTC number so. But the proposal was not required by the DLC due to non-availability of any grade 3 or grade 4 under compensation quota with the parent office as well as any other offices in the district as per qualification of the petition.
and this was 3124.
Better make some other, that is better decided, my lord, the next week or nothing. Thank you, my lord, after that, better verification. Otherwise, my lord, I expected, my lord, item number saying in the series 1, first I think you are also detected by that.
No, that is, you see, the issue, this nitty-gritty, that will be weeded out. All those cases will be weeded out. That is going to be weeded out. So you clarify now. What is wrong with this order? What is wrong with it? You see, the question of 8924 doesn't come right now. 8924 will only come when you cross this hurdle of setting aside the DLC. Now, tell me, what is wrong with this order?
Now, my lord, I, my lord, circular is my lord, hurdle for.
Huh?
There is a circular, my lord, now, my lord, compensation report will be abolished by the state.
No, that is all right. If the DLC, if there's anything wrong with the DLC, we can set aside the DLC. Then we can ask them to consider a compassion appointment because at that time, compassion appointment was allowed. But where is the ground to set aside this DLC?
But I have stated one paragraph, another date.
When did your who died?
Other.
Huh? Who? Father? When? Father died when?
2016.
2016. When did he die?
Only better cover that.
No. We cannot burden all the things. Petitioner's parents died before 1470. There's nothing here. When did he die?
After some time,
Died of 1712.
15 and 16, my lord. Two petitioners, my lord.
How can there be two petitioners?
Yes, yes. Fine, my lord.
Maybe, but it is local
Different-
standard, different local standard.
Different.
Same father, same mother, or what?
Order, different. Order,
Sorry.
in the same meeting, they are different.
Cause of action is different.
Petitioner method one, method, father died 2016, and second one was method died 2015.
No, this cannot be. So this page 64 is only with regard to suppose of Vijit Kumar Singha. This out here says Bimal Kumar Singha. Father, that's the father. And what about petition number 2? When did his father die?
15. 15. His father died 15 months.
Fifty-five. Huh?
Number 2, my lord, resolution 65, serial number 1.
Non-availability.
Same, same ground. Non-availability of vacant post under so and so with the parent office as well as other offices of the district. In fact, there was no vacancy. Page number 60,
Without any material.
page number 61 is the
Without
total
any
vacancy
material,
position.
that's
Huh?
recorded, my lord.
61 is the vacancy position method.
Paragraph, my lord, 10, my lord, I have stated, my lord, this is keep found, my lord.
Nil,
without
nil, nil,
material.
nil, nil.
Reject the claim, my lord. No materials to show, my lord, that's how they can.
Altogether, there was only 5 posts.
Only simple, my lord, one, my lord, that says no presence in all departments.
This is a list. Basically.
And I am challenging this government.
Then you file things, you file. We cannot have a roving inquiry on your behalf.
Page, paragraph 10, my lord, this is my sole ground, my lord, that without, my lord, putting any, my lord, record and, my lord,
Come to
report.
page para 8. It says, but his claim for companionship was rejected and his father had less than 3 years balances. Where is this? Out here does not say 3 years balances.
Yeah, right, this is quashed, my lord, but these are our court, my lord. He approached, my lord, and it is quashed.
Okay, the earlier one.
Yes, sir, this is judgment, my lord, page 57. Passport, and on the basis of, my lord, judgment in, my lord, passport, my lord, this, my lord, it was interfered that rejection resolution of that TLC, and it was granted back, my lord, by this, I will put to consider.
We'll have to weed out all these cases, I think, on that, from the batch of repetition. Wherever the SLC and DLC is rejected, those you cannot challenge the OM because you have to follow the first hurdle. The first hurdle has to be crossed.
Both are prayer are they are
Cannot,
considered.
no, cannot. It will not be proper.
I will the matter make now available those matters. And I will give reminder on that date what are the similar matters for. Number one is same matter, similar matter.
We will weed out all those. All where the SLC has rejected or DSC has rejected, there's no ground to challenge.
Together, my lord, we keep my lord lead one.
Oh, no need, no need. That this can be.
All the matter you are located is group by separating matter.
This case can be referred.
Huh?
In the this matter,
Ah.
but not this, either this.
Huh?
Not vice versa.
Right. Right, Mr.
Same body.
A.M. Burbil, and also for the petitioners who submits that the petitioners number 1 and 2, whose fathers are different, are claiming compassionate appointment on the death of their respective fathers. The petitioner's application for compassionate appointment had initially been rejected by the concerned DLC. So, however, on the basis of the orders passed in writ petitions filed by the petitioner, the case of the petitioners were directed to be reconsidered again by the DL. The DLCs have rejected the applications of the petitioners again by meeting minutes dated 30/01/2024 on the ground of non-availability of vacancies in the parent office as well as the other offices of the district. The petitioners have, however, made a challenge. The OM dated 18/9/2024. This court is of the view that the petitioner's hearing cannot be allowed to make a challenge to the OM dated 18/9/2024, as they have no locus standi to do the same, unless the rejection of the petitioner's application for compassionate appointment are set aside or cancelled. Further, this court finds that the further this court finds that the cause of action being different, the petitioners should have filed 2 different writ petitions and not a single writ petition. Leave this matter when?
Third one.
Third. Leave this matter third. Just keep this in mind, Mr. Pegu, this is case number. So that we'll weed out those.
Yeah, otherwise, one thing may I share that my rejection was before OM. Therefore, my
No, your rejection before OM, after OM doesn't matter. That has got no meaning. It is like this. It is like this. I'll just tell you. It is like this. It's like saying that though I am dismissed from service, I should be promoted. Court will tell you what? First get your dismissal from service set aside. Then only you can get promoted. You cannot get promoted while you are dismissed from service.
on that day, if I am wrong, correct me, past I would have been appointed.
Correct. But then now, unless the thing is set aside, Then on.
Entire scheme is all of
Anyway, listed that. Which date? Third or fourth?
it. No.
Made these lordship. Lordship, the matter pertains to promoting the petitioner to the post of in charge principal in Sipaja HS and MP school lordship. After the petitioner was appointed, who's currently the vice principal of Sipaja HS and MP school, was appointed as a assistant teacher in the year 1999 and he was promoted to the post of headmaster in the year 2011 in Sipaja Academy lordship. Sipaja Academy was amalgamated with Sipaja HS and MP school on lordship 15th of July 2023 lordship. Lordship, the respondent number 4 lordship, who was appointed as an assistant teacher in the year 1990 in Sipaja HS and MP school lordship, and he was promoted to the post of in charge principal in the year 2000.
Do you have the qualifications to be a headmaster or principal?
Yes, lordship, the person.
Yeah, you have the qualifications
Yes, lordship.
and you're senior.
Yes, lordship, and senior because lordship, the petitioner belongs to class 2 cadre and respondent number 4 who is presently in charge.
We'll issue notice.
Yes, lordship. My principal, my lordship, in charge principal. Lordship.
Is there, we'll have to issue
Yes,
notice.
lordship, because
There's no interim can be given.
and lordship, one more prayer, lordship, the impugn order, that is the promotion letter, promotion order of the respondent number 4 lordship.
As in charge.
In charge principal lordship of respondent number 4 lordship, after sincere effort lordship, we cannot obtain that lordship. It may be brought on record lordship.
Okay, yeah, okay, right. Third, Miss R. Parva, Learned Counsel for the petitioner who submit that the petitioner is senior to the respondent number 4 and has the eligibility criteria to be appointed as principal of the school. However, the respondent number 4 has been made the in charge principal instead of the petitioner. He also submits that the petitioner has not been able to obtain the order appointing the respondent number 4 as the in charge principal. Issue notice, returnable in 4 weeks. Petitioner will take steps now. Ms. Please ask accept notice on behalf of
1, 2, and 3.
1, 2, and 3. Petitioner will take steps for service of notice upon the respondent number 4 by registered postal daily within 3 days, within 4 days, within 4 days. This is the matter. Give a date. Ms. Pidas shall produce the. No, don't say the respondent can be. This is the matter of the.
Keep your.
We are claiming the potentialism on the basis of information. Earlier, with the lawsuit for big petition viable. It is on matter 1616 again kind of 160.
No, what is to be done here?
And a notice taking similar order may be passed by law.
Say right, heard Mr. P. Mahanta, learned counsel for the petitioner who submit that despite being found eligible for provincialization under the 2017 Act, the petitioner's service has not been provincialized. That's all.
Similar order that may help you.
That may help you. Without
Because when their position also mentioned like comment the law. My position
same letter date, letter number, everything same.
it's same mine. Same.
A petitioner's name is listed as serial number
Serial number 53 mine.
53.
It is school also mine. It is Pandua school.
Out here I have not mentioned any school.
But it is a serial number.
It is-
Later what's it?
Okay, I'll say Miss P. Das for respondent number 1 to 3. And for 4, Miss N. Huh? Who? G. Pegu. G. Pegu. Okay, same order. Annexure A, out here, Mr. Manta. Same, annexure A is the letter,
Yes, my lord. This is same, my lord.
only that serial number.
Only serial number is
And GPEG has to be changed.
50.
And
Instead of the four pictures. If you.
If the export approval appear in this matter.
only notice will go, that's all. What is your name?
Lordship, one more thing. This is 13 and 14 are identical matters.
Item?
13 and 14.
Okay. Heard Mr.
Khatoniya.
Pete Kataki.
Khatoniya.
Huh?
Khatoniya.
Katania, Learned Council. Appearing for the petition. Who submit that the petition is to be given the lecturer selection grade pay.
Seniority.
The selection grade,
Senior.
Huh?
Senior grade.
senior grade, not selection grade.
Senior.
Are you sure?
Sure. Senior grade.
Okay, so allow the senior grade pay.
Yes.
Lecturer, senior, yeah, the senior grade pay. From the date of his eligibility. Under the, as the promotion has been done under the CS.
Yes.
Under the
Political.
CS. Pusta. It happens that the benefit of the senior grade pay cannot be done from a date beyond the date of eligibility. If you notice, returnable in 4 weeks, Mr. S. Das accepts notice on behalf of, all the spots. Then in the other one also, senior,
Different stages, Your Honor.
and different, that's a different thing,
Whatever is the identity.
senior. No need of putting everything.
The context.
Petitioner because lordship is student, my lord. He had got admission in JNV.
मतलब before my learner friend starts,
Huh?
before my learner friend starts, मतलब मैं make a small prayer, मतलब in this state petition, मतलब the prayers are made primarily against the respondent number 224,
Are made against 2224.
224, the standing count for 224 is Saurabh Chaudhary, today's difficulty, she is not available today, so may I pray that this matter may be taken up Wednesday, any day in the next week.
Yes, what is your case?
He is my lord, the petitioner is a member of the OBC. There were two petitions pending, my lords. And there is a direction to,
You are interested in one only.
but my lords, pursuant to that, my lord, direction and a petition, my lord, and actually here, we have preferred an application to deputy commissioner to give us the caste certificate. Deputy commissioner is sleeping over it.
Where is that representation to the deputy commissioner?
There's an application.
Where is it?
It's annexure D, page 59. Nowadays it's automatic.
Okay, this is
Yes. They were sleeping over it. Now the JNB authorities, they're insisting that I should come up with a caste certificate. So I applied for it. Now I'm giving my final exams. In the midst of my this exam,
20,
they say
when did you give? 23?
5723.
How can it be 5723? The order passed by the High Court is on December 23.
5/12/2020.
Huh?
5/12/2020.
Correct, 5/23, December 23, the order has been passed.
Well, since but
No,
for that
because,
also, Malad,
no, no,
so they had applied.
no, that is a different thing. You see, what has the High Court said? What has this court said?
Paragraph 37.
Yes.
Well, since they had applied earlier, my lord.
No, no, let us see what this
Before
court has
coming
said.
to court, they had applied. So there was no scope of applying twice, my lord. So this is the application we are relying on.
The council, let us look at para 39.
There are 30.
Down to page 57, the next
Yes, yes.
page.
We are
Please
required
read, please read. Don't be in a hurry.
We require, for the first one, all the para the paragraph 30.
We require that the petitioners from the bottom, from the top.
Directly approach the state level caste scrutiny committee and produce the relevant material before the
Yes.
committee substantiate their claim
Yes,
that they belong to so and so community. A report thereof be provided to the petitioners based on such report. The petitioners may approach the deputy commissioner again.
correct. You
Concerned
have to
formally
approach.
issuing the certificate.
You have to approach. That's all.
There is no avenue for approaching twice. My lord, we had approached. Before that, instituting a petition, my lord, we had approached in 5723. They are skipping over it. That was the entire case.
No, no. Why didn't you tell the court? Why didn't you tell the court that you had already approached? What?
My lord, just P9. Full body. Now there is another writ petition.
I agree, but it was disposed of by a common
In
order.
that writ petition we are annexed. In that writ petition, madam. In that writ petition, madam, it was
Mr. Counsel,
397.
whatever it is, this court has not said that the deputy commissioner should dispose of your representation is submitted on 5723. It has said that you are required to directly approach the state level caste scrutiny committee and produce the relevant material before the committee. You see, you have not approached, you can directly approach the state level caste scrutiny committee. Your earlier procedure was, you give it to the deputy commissioner will produce it before the state level scrutiny committee. Here, the court has said that you directly approach the committee. Where is that?
But
Where is the letter to the committee?
The honorable court asks us to follow the judgment of Madhuri Pandit.
Maybe. But this is what the court has said.
But again,
If you find that this order is wrong, you could have asked for a modification of the order.
And in paragraph 8 of the repetition, my lord,
But
it was
paragraph
stated,
37 Lordship,
they have not approached. Ma'am. Paragraph,
Para 8.
yes, my lord. 6 line from below. May I read, my lord? Therefore, the petition,
Para 8. Yes.
my lord, I'm sorry. My lord, 6 line from below, my lord.
Yes.
Therefore, the petitioner did not make second application for
Ah.
certificate. So,
No judgment or order.
order that this honorable court directed the petitioners therein to make application before the concerned bench.
because my lord, twice we cannot apply. Lordship will kindly see para 37. There's only one window, my lord. One person is given only one chance to apply. There's a barcode supplied. If I, my lord, I personally make an application before the authority for a service, I will be given a one specific code against it, my lord. I won't be allowed twice to invoke the same service.
You see, Mr. Kaushal, you could have always come back to the court by way of the same case, by way of filing a misapplication, saying that your order cannot be complied with for the simple reason that we have already filed on 5 July 23, and as accordingly, please make a modification of the order so that to the effect that the application already submitted by me should be decided. You could have done that.
In that case, the lordship will kindly pay us 37, para 37.
Yes. Yes.
Here again, it says, we accordingly require the petitioners to make an application of revenue.
Correct. But 37 has to be read along with 39. You cannot read one part only which you like.
And 39 again, my lord, in 38 it says comply with Madhuri Patel. Madhuri Patel again says go to the
Correct. So
district.
please go to that, you should have gone to the court straight away and said that, look, your orders at 37, 38, 39 are not being capable of being implemented.
My lord.
So please clarify this order. But now you're coming by way of a different writ petition and saying that, look, they are not taking a decision. But then para 39 is there. You see, when we read a book,
My lord.
we come to the final ending, and the entire story plays out at the end. The entire story doesn't play out in the middle or somewhere in the beginning. Usually what happens is at the end, you will see a movie, the hero will win at the end. Everything will be happy. Happy ending will come at the end only. Then there's nothing, the story doesn't finish in the beginning. So here also, when you're reading a judgment by a court, you have to read the entire judgment to understand what the court has finally decided. Court has finally decided para 39, not a 37 or 39, 38. What are they arguing just for the sake of arguing?
In that case, my lords, then we'll comply with that equation is still
You
pending, my lord.
comply with 39.
Will directly approve approve the committee, my lords.
That is what has been told. That is what has been told. That is the direction given to you. Approach them
Yes,
directly.
we'll approach
That is
directly, my
the
lords.
end of the matter.
Will directly approach, my lord, till there, my lord. My academic interest will be protected.
Huh?
My academic interest, my lord, these kind of letters, they
Lord,
issue,
it's
my
a
lord,
order
and
of
it's a
5,
exam.
12,
I do not know now also you did not. You see, this order was passed in 23
More than one.
December. More than 1 year passed. You did not do anything. You kept quiet. You were happy with your 5/7/23 application. You get it, then maybe we'll protect you later on, not now. And the date
I
has
have
also
instructed,
passed.
my lord, that we are waiting for the commit, the DC. We are waiting for we relied on the DC's communication that we will be calling. Neither we have also been not called back. No, no,
Why don't you go to the committee in the first place?
yes, we'll now directly approach.
You have to approach. That's all.
My lords.
There's
That
no
will also
problem.
serve our purpose, my lord.
Right. Mr. So what is to be done? Mr. D. Ogoi submit that the petitioner will directly approach the state level caste scrutiny committee with all relevant material to substantiate their claim that the petitioner belongs to the OBC community. In terms of para 39 of the judgment and order dated 5/12/2023 passed in WPC 397 of 20. Mr.
He does, Malak.
He does.
Yes.
Appears for the
Appearing for respondent number 224, Malak, on behalf of R.S. Chaudhary.
224 on behalf of Mr.
R.S. Chaudhary. Miss
R.S.
R.S.
Chaudhary.
Chaudhary.
MS MSRS.
R.S. Chaudhary.
Acha, miss. Right, next, right. In view of the submission made by the counsel for the petitioner, there is nothing to be adjudicated in this petition. However, in the event the petitioners approach the state level caste scrutiny committee, which should be not later than 1 week from today, the caste scrutiny committee should take a decision on the petitioner's representation within a period of
Malak, they are the state. I am the petition listed.
if expeditiously,
Respondent number 7.
expeditiously and preferably within a period of 2 weeks from the date of receipt of the representation. 30 days. Okay, 30 days. Mr. G. Pegu appears for point number 5. Very good. So he is there.
Until then, my lords, at least till then, my lords, this child may be, because she's studying, my lord, no more these kind of letters, my lords.
Huh?
No, this kind of letters should not be issued, my lords.
What letter?
Page 61, my lords.
My lord, in any case, academic section is over, my lord.
That's what I'm thinking.
No. What
The
purpose?
academic section is over.
It's
There's
over.
nothing,
It's over.
there's nothing to protect now.
No, still there, my lords.
Till then what?
Still there, my lord, the petitioners, the according to be refrained from this kind of communication. Till the because
Page?
61, my lord. They're going to admission cancellation. After my admission is cancelled, but nothing remains. If I get a good certificate from the Caste committee also, it is just a academic exercise.
But it was
That is
you,
not-
it was you who did not follow the directions passed by this.
Another just add, my lord, till the committee report now. At least that, my lord.
My lord, it was only to produce the caste certificate.
Huh?
We are not issuing any TC, my lord. It
No,
was only
there was,
to,
I have instruction, I have
The issue of the, no,
that big recorded, they are not issuing any teaching. At least till this process comes to an end, the legal end.
my lord, if he brings a valid caste certificate, obviously we will admit it. If not, then we'll have to cancel that.
So till the exercise is completed, not teaching.
no, not that exercise. Then we had a problem here also. Appeal was to be filed until then the interim order would be passed. That person didn't file an appeal. So interim order continues. So that cannot happen.
But lordship, this child has a good academic career, my lord.
That is
No, my
your
lord, she entered with a caste, no doubt. But academically, she has been performing well. That's the reason she's been getting promotion to other classes. Promotion is not based on caste. So at least that way she may be protected till that, my lord.
In any case, my lord, next session will start.
when admission will start when?
In the month of April, my lord.
April. April is next
March
month.
and April, how much difference, my lord? Let the, at least.
Okay, till
Not TC till the exercise is done, my lord.
Till the academic session starts, will
That may be required.
academic section will start when?
in the first April, my lord.
1st April.
Yes.
1st April is just next week.
I'll leave it to, I'll leave it to the first week. If the process is expedited, my lord, then things should be easier for us.
The petitioner can also show proof of submission of a representation regarding the issue of caste to be decided. No, shall also show proof of having approached the state level caste scrutiny committee within a period of no to whom
To the record number 4, my lord.
to the principal PM Shri School Jawahar Navodaya Vidyalaya Deepu Karbiangla within on or before. Within what date? On or before. 4 4 4 4 4 25. In the event, proof of the same is shown, proof of having approached the state level caste scrutiny committee is shown to the respondent number 4 within on or before 4.
Yeah.
There's not
7 to 2.
there is there a scrutiny committee in Diffu? Huh?
I met him outside while I was asking for notification. They are not handing over that also. What rule they have now?
No, anyway, it's good that they've come. You cannot pretend to be angry, Mr. Tito. You're the one who was You did not obey the orders of the court for 1 year. You've got no case with her. Miss J. Gogoi appears for respondent number 7. That is the state level caste scrutiny committee. She submits. Yes, that's a summary, right? She submits that she has not received a copy of the writ petition. Mr. D. Gogoi shall furnish a copy of the writ petition to Ms. J. Gogoi during the course of the day. One copy or 2 copies? Shall submit 2 copies of the writ petition during the course of the day. So what we're doing is we're disposing of the entire case. They will submit a representation to the committee within within a week. That means by next Friday, and you decide within a month. Can you decide within a month, or you need less days? 3 weeks? Huh? No instruction. No instruction. I'm disposing of. No instruction. You're wasting time taking instruction. So whatever I said. That's point number 4. Should not act upon the impugned letter dated 28/2/2025. Till a decision is taken by them. It's not till a decision, not till a decision, for a period of 1 month. Well, by which date? No, that's for a period of 1 month. So that you also push, they also push, otherwise there'll be a problem.
Let's wait for another offer.
JNV, so that's what I was interested. It's fully JNV, so that's the reason behind it. So much education.
But you all should have filed the application before the committee itself. That's what the court has said.
May I pray for another observation?
Yes.
Your lordship kindly put an observation that if the committee furnishes a report, or if the caste certificate turns out to be an invalid one, then we are at liberty to issue a transfer certificate to the petition. It's already there in the other.
It's already there.
Yes.
How does it matter?
Well,
That though is always there.
I'm obliged.
Only protecting him for 1 month. After that, you can do whatever.
Well.
You can send him to Tihar jail also, whatever. Doesn't matter.
That's deeply over.
All right. Right.
My lord, matter relates to my lord, the sense of the surname of the petitioner, my lord.
Huh?
Surname of the petitioner, my lord. Because petitioner, my lord, when she was a child, my lord, father left, my lord, father. Now after my lord getting majority, my lord, she comes to know that the father of where he is, my lord, staying in Villain, or there is a, my lord, adoptive father, the biological father still alive, my lord. So now, my lord, she wants to send her, my lord, surname with the father's name also in the editorial records of metric and high secondary, my lord. So I filed an application before the, my lord, authority. My lord, now they are, my lord, not want to change, my lord, his surname, my lord, because of, my lord, I think there is no provision at such, my lord, changing of surname in the, my lord, Seva, my lord, or in the council. In the affidavit, they say that only clerical mistake they can.
My lord,
rectify.
change of my lord surname, there is no provision at all, madam. Only in clerical error, sometimes the error, if in clerical error is kept with one of the writing certificate or another document, then that can be corrected within 3 weeks, 3 years from the date of commencement of the examination, he or he has to apply. But in this affidavit says that the board did not receive any application in this regard. So time is over. Now, question is, my lord, earlier biological father written Thai, no? Biological, Millie. And her mother left the biological father and married with some other person. So accordingly,
Is that a proven fact?
no, my lord, we cannot say, my lord, because there is no provision at all.
Huh?
In our regulation, there is.
When did the petitioner's stepfather and mother, when did they marry?
My lord, when I was, she has 3 months baby, my lord, then my death with me.
Where is all that?
And I have made party to my lord mother also, that my lord, the adopted father also.
They had not come.
My lord, my mother has my lord, repeated my lord. That must be. But notice have been duly served, my lord.
So let them appear the natural, my lord, parents.
My the biological father, my lord, yes,
Call your mother. Call your mother.
my lord, lordship, there is an my lord, Assam Gazette notification, my lord. I have, my lord, put in the notification.
Assam Gazette notification doesn't mean
Doesn't
anything.
help.
I mean, I
Become
can
a
go and
government
make.
document, my lord, it is published in the my lord Gazette.
Maybe,
Become a government
maybe,
document.
maybe.
They can, my lord.
Everyone, even I can go and change my name tomorrow. It will be done.
Well, I have met party, my lord. In notice been duly served.
If it's your mother, why can't she come? Your stepfather's name is what?
My lord, this, that Rupeshwar Mili, man. This is a biological father.
Millie.
Mili.
And your
Stepfather,
stepfather's name?
That my lord,
Tuleswar Misong.
Dileswar Mishang.
Mishong. They are what? They are ST.
Oh, my lord.
ST.
My lord.
The stepfather also ST.
My lord.
The real father also ST.
My lord. I belong to mixing community.
So there will be no real advantage. Because in employment, no real advantage. No real difference. Only thing is whether you are the biological father or biological daughter, we don't know. That has to be proven.
No, my biological father, my lord.
Better, my lord, petitioner
That
approach
is just
the,
Made an
huh?
better, my lord, petitioner approach the civil court, have a declaration, and on the declaration, they submit to the board, my lord, board will. Because without declaration, my lord, board cannot.
Because
so there is
evidence is
It is not a civil case.
Huh?
It is the matter of my lord, Article 19, my lord.
No. What Article 19? Which Article 19? Which article? Tell me,
I can express anyway my name.
You can express
Only
anything.
formality has to be observed.
You can express anything, but we have got to prove your name.
That's why, my lord.
You have got to prove that you are the daughter of your biological father, supposed biological father. We don't know.
They did not deny it, my lord. My biological father, he is a my lord with me, my lord. I am sure, and there is a affidavit also, my lord. Even in a government gazette also, my lord, may come to the page 25.
Where is your biological father here? He's not a party here also.
My lord.
Where is he?
Page 25, my lord.
No. Where is he in the list of parties? where is the list of parties?
No. Headmaster,
He's not a party here also.
No, my lord, on my lord, because I am with him, my lord. On his address, I filed this petition, saying he is my father.
Look, if you are a minor, I could understand. But you are not even a minor. You are an adult. He's an adult. We do not know. Your father also has to say that yes, he is my biological daughter.
And I have to met him party, my lord. Then
You do whatever.
my lord.
I think best is you go have a declaration made by the, like you said, by civil court. Let evidence be taken. Let evidence be taken.
Yes.
Once evidence is taken, then no problem. But right now, because out here we cannot take evidence.
civil court declare it there, so.
Yes. Once it is declared by civil court,
Yeah.
then it's easy.
You can also my lord.
I think better.
My lord. I'll make him party my biological father, my lord.
You go to civil court.
That is the provision of your Jogya Jadab case also, my lord. Possible earlier.
My lord, in another case, my lord, the Governor to court has passed an order, my lord. I have the counsel, my lord, regarding one Hiral Park, my lord. His name was different. He'd like to rate as a Hiral Park, my lord.
Huh?
Hiral Park, wrong for my lord. They have surname of the Hitler, my lord. So he have been allowed by this honorable court, my lord, to change his name, my lord.
No, changing of one's name is different. But when you say, when you claim to be supposing tomorrow,
That I am changing the title, my lord, my
no, correct.
place of Bishong.
Now you say tomorrow, supposing I say Datta is my father. I want now my name to be Michael Datta. Supposing. Now looking to you say no chance. Correct. Now he's not now that Datta, you'll want to see Datta also, whether he looks like me or something like that. Only thing is that less hair, that is the only similarity we have.
Yes.
Now, so because of that, you have to make someone a party also, so that he will also say, yes, what the petitioner is saying is correct. That is one aspect. But besides that, also evidence is required. So that
I am saying my biological father. My lord, he, after my lord, become major, he
when your biological father is not saying that, you are saying. Your biological father also has to
yes,
say.
affidavit by biological father.
No,
my lord.
no.
That is it. Annexed.
Not that way.
Yes,
Not,
it's a annexed.
not that document that you have submitted has to be proved. This is more a civil court matter.
My lord, that is not a dispute against anything, my lord, title and all, my lord. This is only surname. Cannot be a civil dispute, my lord. Read court, my lord.
He has to be a
If
party
there is a,
anyway.
my lord, text support me, my lord. Then
No,
read court.
here, where is there
If there is a dispute, they have said something, that is
no,
different.
surname from Misong to Mili and to correct the father's name from Tules to Misong to Rupes to Mili. Name also.
Name of?
Name also. This was the page 12. Paragraph prayer 1. To allow the petitioner to change their surname from Misong to Mili. 1. Next, to correct the father's name Tules to Misong to Rupes to Mili.
Oh, to correct her father's name.
Yeah.
I'll make party, my lord.
Huh?
Biological father will make party.
I don't know who is the biological, who is the father.
Let me, I
To
am.
correct her father's name.
Yeah, father's name also.
Acha, to correct the no, naturally, to correct the father's name in the because father's name is there in the certificate as thing. No, this is all right. This is all right. Understandable. But I think civil court is best.
Yes.
My lord, I'll make party to my biological father.
On the prayer of
Because
the
he's the
petitioner's
person who
counsel,
has to
this is the
say,
matter
my-
of the 4 weeks.
Oblet. Yeah, please, your lord.
Item?
One.
Yes.
Matter, this matter has already become insufficient. And we have no communication with the client.
Okay, right. Mr.
S. Rabha.
S. Rabba, learned counsel for the petitioner. Probably 2017. Submit that the matter has become important. Mr.
KJ,
K. Jain appears for
respondent 1 to 4.
1 to 4. While Mr. Okay. Y. YN Mahanta appears for Mr. A. Chamwa, learned counsel for the UG on the submission made by the counsel for the petition. The petition is closed, is dismissed as in. Next. No one appears for the petition on call. Who appears for the other side? You're for the?
I am for the other side.
You're the principal, in charge. In charge principal. What is this case?
What I said, well, what is this case about? The student because of
Anyway, right, no one appears for the petition on call. Mr. DJ Das appears for the respondent number 5. Mr. B. Kaushik appears for the Secondary Education Department. This is the matter after 4 weeks. There is no stay order, I think. Consider 2018 matter. It must have been decided already. Why don't you obtain instructions? Okay. Mr. B. Kaushik shall obtain instructions as to whether the petitioner's representation has been decided by the respondent. This is the matter after 4 weeks.
From Provincialization.
Huh?
There are two numbers of petitioner, both are the science speaker and here services.
So there is no, okay. So affidavits are there? No affidavit.
Affidavit being filed, one affidavit, but few of the additional affidavit that has been filed. We would like to file our reflect, some new factors.
On last petition, as there is a in respect of petitioner number 1, my lord, after filing this petition, my lord, there is an interim order was passed, the convention. That must be passed.
That is not an interim order. That is just an observation.
Communication is going on. In that respect, another report that some instruction today.
So no. Out here says that he will file comprehensive affidavit. Mr. B. Kaushik is granted 2 weeks time. 2 weeks time to file affidavit in terms of the order dated 5/3/2020. This is the matter after 2 weeks.
It may be 6 months.
Give it in. No one appears for the petition on call. This is the matter after 4 weeks. Same order. Yes, who is here?
My lord, an order, lord, at page 34 is under challenge. What they have done, my lord, they have regularized my gap period from 1798 to 23/2005 only for the pensionary benefit, but no other benefit they have decided to be given. But my lord, why I am not entitled? What is the reason behind this? My lord, nothing is explicit. My lord.
Yes, who is appearing?
No affidavit I have received till date.
Miss Das, how much time?
3 weeks time.
Miss Das is alert counsel for the secondary education department. Is granted 4 weeks time to file affidavit. This is the matter after 4 weeks. First time after 2021.
Apply.
In item number 22, my lord, I am preparing for the respondent number 5. We have filed our affidavit in opposition.
That was told, your lord.
Huh?
That was told, your lord.
Huh?
Lordship, I'm item number 22, Lordship. Lordship, we are trying to reach our plan, Lordship. We need some time for instructions and also, Lordship, they filed an affidavit in opposition. We also need to reply to that.
Told, your lordship, respondent number 4 has main rule, your lordship, that
Who is respondent
The
number
ad
4?
hoc Committee for TET secondary education.
Oh,
represented by
who is appearing for respondent number 4?
whoever.
For respondent number 4. 3694 for whom? SSA. Okay. So what about you? So Miss P. Das, you're not filing anything?
No, Your Honor.
What about you?
My lord, I have already filed my lord for on behalf of respondent number 5,
In both?
both my lord. In item number 22,
What about 23?
with not filed my lord.
Okay, right, Mr.
T. Khatoniya.
Huh?
T. Khatoniya.
P. Khataniar appearing for the petitioners submit that he has not been able to communicate with his client. He also seeks time to file reply affidavit to the affidavit in the position filed by the respondent number 5 in WPC 5236 of 2021. Mr. S. Bora, Learned Counsel appearing for the respondent number 5 in 3694 of 2021. Submits that as instructions have been received, he will be filing affidavit within 2 weeks.
My lord, in item number 23, my lord, SEBA has not been party with
Okay, no. Mr.
DK Roy.
DK Roy appearing for SEBA in WPC 5236 of 2020. Submit that affidavit has been filed. Ms. P. Das appearing for the Secondary Education Department. Submit that they will not be filing any affidavit. List after 3 weeks.
Okay, the date may be fixed.
You first contact your clients, make sure.
In item number 22, they are not able to contact their client.
Okay, this is the matter after. Give a date.
Right, Lord. Not okay. 24.
Yes,
On the last location also, your lordship petitioner on call, they have not appeared.
so many years back, man. Very smart. Right, no one appears for the petition on call. Ms. P. Das appears for the Secondary Education Department. In the interest of justice, list the matter on on 7?
Yes, Your Honor. For last chance, your lordship.
Yes, on 7.
Deeply.
Oh, yeah. Item 20,
Burhan,
24.
Yes, sir.
Oh, they are here.
Lordship, this matter is covered by a coordinate with judgment, Your Lordship.
No, what is this case about?
Your Lordship, promotion from LDA to UDA in some districts of Hailakandi, Your Lordship, there is a direction of Directorate of Secondary Education where it was meant to be said that resolved that all the inspector of schools from different districts of Assam shall take necessary steps to publish the seniority list, followed by upgradation of and promotion of LDA to UDA. But it was said that in their petition that Hailakandi, Your Lordship, some was not implemented in the district of Hailakandi. So, Your Lordship, the inspector of his school HDHC Hailakandi.
He has got this order. You just look at it, huh?
Your Lordship,
Pick some other day.
Your Lordship,
Yeah.
I'll
Right,
obtain
Mr.
instruction in this regard,
Huh?
Your Lordship. Whether it is
R.A.
there or
Malhotra,
not.
Learned Counsel for the petitioner, submits that the present case is covered by the order dated 5/6/24, passed in WPC 8/76/2020. Ms. P. Das, Learned Counsel for the Secondary Education Department, submits that she needs time to go through the same and obtain the instructions. Accordingly, please this matter after the vacation.
Keep your bed.
So case my lord, this is covered by a similar judgment, my lord, by a court of a coordinate bench.
This is what regarding marks.
Yes, my lord, there are certain guidelines as per which my lord I have to be selected if I am the one scoring the highest. And whereas the respondent number 7, while I scored 69.576 marks, the respondent number 7 scored 39.315 marks. Despite that, he was selected, my lord, and his recommendation has gone to the Director of Higher Education.
How come there's such a big difference?
My lord. And they have not denied our allegations. The college has not denied our allegations. They say that it was done by the previous incumbent selection committee.
No, but how can it be done with the marker? Anyway, this matter.
Your Lordship, I have filed the affidavit in opposition. I have picked up of 356.
356 have got nothing to say. Correct?
Yes.
Is it? Or you are the main person?
No, I'm
They
the main person.
selected, but they say that it was the previous incumbent who did this. So we are not.
Before higher education to
Higher education, where is Miss Pidas? He has suddenly done the vanishing act.
Lordship may look at the affidavit in opposition.
Yes.
Throughout, they have taken this stand, para 7, my lord.
Yes.
37. That the governing body of the college constituted a selection committee for the selection of the candidates for the above mentioned posts, with Mr. Dharanidhar Talukdar, president of the governing body, as chairman of the selection committee, Dr. Mukunda Sharma, principal, as member secretary of the selection committee, and Dr. Abdul Salam, vice principal and senior most teacher of the college, as member as per the existing rules of the government for formation of selection for appointment of grade 3 and grade 4 employees of the colleges. This reiterated once again here that at the material time, the deponent was not holding the office of the principal and secretary of the college.
Where have you mentioned the marks in your writ petition? Para 8. Para 8.
Age is also, he is 56 years old, respondent number 7. They have in their advertisement, it says 38 years old, subject to relaxation for SC candidates. Would be 5 years, so 43 years. Para 8, page number 10, my lord. Paragraph at top.
So they have not made any reply to para 8. Yes, Mr. S. Das.
Para,
We are for the secondary education.
I, here what happened when there's another case, the same application, different post, similar situation, my lord. The honorable court quashed the selection and directed the selection committee to append the name of the petitioner in that case
or approval of the directive. They then would be considered by the selection was square. Included the
Selection was squashed.
Yes.
You see, the thing is that purportedly he's got higher marks. There's a difference of 30 marks between them. How come the respondent number 6? Who is the respondent number 6? Has he appeared?
We have received notice after the octave, but nobody has. In the other case, also same, the private respondent did not. The hierarchy, but or before it take the proposed step by the.
Is that provincialization rule? No.
So there is a separate guideline, my lord. Connect the director of the reflector. Or it may be para 10. Yeah, it is.
Para 10 of who? Whose affidavit?
No, my lord, I have that 9 and 10. Maybe
Yes.
it also appears from the comparative chart annexed 10 at page number 48 of the petition that the present petitioner whose name is reflected as serial number 17 obtained 85% in HSLC examination, and the private respondent number 6 whose name is reflected as serial number 8 and who was selected for the state post obtained only 32.55% in HSLC examination. In the affidavit in opposition, the respondent numbers 3 and 5 failed to offer any plausible explanation as to how they have selected the private respondent number 6 to obtain only 32.55% in HSLC examination instead of the present petitioner who obtained 85% in HSLC examination. The learned standing counsel for the respondent numbers 3 and 5 had admitted aberration on the part of the respondent numbers 3 and 5 at the time of hearing. Having examined the selection of the private respondent number 6 in the light of the given facts and circumstances on the record, this court is of the view that the selection is arbitrary and illegal and the same failed to withstand the legal scrutiny, and on such grounds, the same deserves to be set aside and quashed.
So the selection is done by the 3, 5 and by this by the school.
Yes, the college.
College.
Yes.
So this 3, 5 and 6 are the important. This the
Yes.
affidavit submitted by them is important.
Similar affidavit here. Ma'am.
But my point is that during that time, I
Ah.
was not the.
Huh?
I was not, my petitioner has.
Correct. No, you're not. So we are not blaming you.
Yes.
Only thing is that so it appears that it's very wrong. Correct. Right. So we'll but then should we ask the selection committee to select again afresh or what? Or what is to be done?
I have appeared. In this case, the Honorable Court directed that my name be sent because I was the topper.
No, I'm talking about this case.
Here
That is
also
a
I'm the
different.
topper.
That's all.
Yes. They will have topper, but
Right. Heard Mr.
yes, they know.
S. Dave for the petitioner. Also heard Ms.
As Antonia,
Catanier for
3, 5 and 6.
3, 5 and 6. While Mr. S. Das appears for respondent number 1. Good point. No, that's silent. Similar. No, it's okay. The petitioner has paid for setting aside the selection list dated 23/4/2023 issued by the selection committee as well as by the governing body of the Bhawanipur Anchalik College, by which the name of the respondent number 7 has been selected for appointment as junior assistant under the SC category in pursuance to the advertisement dated 18/3/2020. Next part. The petitioner's counsel submit. No, before that, you're right. No one appears for the respondent number 4 and 7. Full stop. However, office note dated, no, however, the proceedings of the Lower Zima Court dated 9/1/2025 states that service is complete in respect of respondent number 4 and 7. Next paragraph. Otherwise, the petition reveals that. Next. The case of the petitioner is that this second para, order dated 6/9/24. Second para, then third para. Miss so and so, learned counsel for the respondent number 3, 5, and 6 submits that at the relevant point of time, the present respondent number the relevant point of time, the present principal in charge and secretary of the governing body of the college was not holding the post of principal and secretary of the college. That's all. Anything else? Madam, you. Anything else? Nothing else. Next. Mr. S. Das, the counsel appearing for the respondents number 2 and 4. 1 and 2. 1 and 2. Submit. Submit that as the director has not taken a final decision on the selection made by the selection committee / governing body for appointment to the post of junior assistant pursuant to the advertisement dated 15/3/2023. The grievance of the petitioner can be looked into by the director, who will thereafter take a final call on the issue. Correct. I have heard the learned counsel for the part. A perusal of the affidavit in a position filed by the affidavit filed by the respondent's number. By the principal in charge and secretary of the governing body of the college shows that there is no denial of the petitioner's averments made in paragraph 8 of the writ petition, which is to the effect that the petitioner had secured 69.576 marks as against the marks secured by the respondent number 7. That is 39.315 marks during the selection process. There is also no averment made by the respondents number 3, 5, and 6 in their affidavit. Depending the selection of the respondent number 7 for appointment to the post of junior assistant. The facts as can be culled out from the pleading clearly shows that there has been an illegality committed, inasmuch as the petitioner had secured higher marks than the respondent number 7. In that view of the matter, this court is of the view that the selection of the respondent number 7 over the petitioner seems to be arbitrary and unreasonable. Accordingly, the selection of the respondent number 7 by the selection committee set aside. The director is directed to the college authority. So we have to send it back to the college authority. I know, I send it to the director now to take a final call and decide on the materials available. Petitioner and the respondent number 7. The director is directed to take a decision as to whether the petitioner or the respondent number 7 should be appointed to the post of junior assistant of the college on the basis of the marks secured by the candidate in the selection process pursuant to the advertisement dated 15/3/2020. The selection is not being the selection process is not being remanded to the selection committee on account of the reasons stated above, wherein it appears that the selection committee has not been fair in selecting the respondent number 7. That is petition accordingly disposed. No? Before that, the entire exercise to be concluded within a period of no need, no?
Sometime maybe fixed,
Within a reasonable period and not later than 2 months from the date of receipt of a copy of the card. The writ petitions accordingly disposed. Huh? Meeting? Meeting? Then we'll do that too. Yes, what is this?
That regarding closure of a institution, they were imparting
Yes,
laboratory technician post.
Yes.
They will come under the scheme under the allied health services.
Okay.
Now, the last occasion, a statement was made from the side of the petitioner that they will only run the office and they will abide by the scheme and they will apply. If that undertaking is recorded, only the office is functional, then
So
here,
the institute comes within that framework.
yes, madam. So what I say, my lord, they will post it immediately after vacation. I will file it. I assure my lord, I will file it, my lord, on the reopening day, and it can be, my lord, decided with the policy of the government. Man. Only, my lord,
Reopening means
after the PU, my lord.
until then?
My lord, the order is of July 2024.
Oh, 24.
Not that, my lord, immediate. Something can be done.
It comes within the framework.
It will come under the allied laboratory technician and all that.
When can you file the affidavit?
My lord, 28. Sir, I will, on 21st, I will find it.
No, you file it before Bihu.
Then, my lord,
He will take time again to file reply.
by 11, I will find it.
As date, no chance. You will not file it.
Then, at least 11 or 10th.
You file it by 10th.
10.
So we list it on 10th so that if they want, they can file a reply then we can take it up on,
My lord, I maintain that we are running.
Mr. Council, I've heard. You see, the issue
My
is this.
lord, we are in a very difficulty because the institute was filled on 16th of July. Okay, on the last occasion, I pleaded, I made a prayer there. The principal's room should be reopened. If necessary, I will vacate. I will try to get the NOC within 2 months. And if I fail, I will close down the. This is the instruction from my client.
Then, my lord, of course, considering, my lord, his undertaking today, then, my lord, only that office may be allowed to be opened, and he will, my lord, abide by the policy. He will apply.
I will apply.
But there will be no class.
So there will be no classes.
Yes, that would be very specific.
So we'll close the entire writ petition then. What do you mean?
Otherwise, nothing will be.
Since you are undertaking to apply for the license,
For the NOC.
for the NOC in terms of the framework, and depending upon the decision to be taken by the, by the authorities, you will either open or close the institute. We will allow you to open the principal's office in the time being, till a decision is taken by you.
But no, we will proceed after 2 months, my lord. Don't
Why?
know what they want to do. Yes, my lord. I will communicate with the authorities. Take, my lord, after 2 months, but yes, sir.
No. You see, you have to complete it within a particular time frame.
No, there will be inspection and all, my lord. If there is anything.
You take time. How much time do you want for inspection?
So he will, first of all, he'll have to apply there.
We will tell him we will apply within how much period of time?
I have the instruction that I already have included the losses because I am paying a house rent.
Mr. Council, I'm not on that. You might, when will you make the application for?
In 2 months, we will make application. If we fail, considering our infrastructure, faculty,
We will proceed on second. I will have the specific instruction. What is the time frame required, my lord?
Okay.
We will dispose it on that day. No other instruction, only on that point that what time will be required from our side, moment we apply. Then on giving a time frame, not to be. You can wait till second.
Okay, you see, you also should have, you also should obtain instructions. Why should you take 2 months to apply? Why don't you apply within 2 weeks?
my lord, their framework is such that it is not merely an NOC. First, they will issue me one LOI. Thereafter, after LOI,
Let us see the framework.
after LOI,
Page 22.
Page 22.
22.
Yes. Let us see.
thereafter LOP from medical and from health and medical education and research department. Thereafter NOC,
Now let us see where is that LOI?
page 21.
Roman to 1. The applicant-
LOI Roman 2:1.
Yes, sir, page 22. Procedure for applying for new nursing, pharmacy and allied health service.
Yes.
The applicant trust or institute must fulfill the minimum standard requirement to first obtain intent of a letter of intent from the Directorate of Medical Education of Assam with the approval of the government for establishment of a
No,
new.
this LOI has to be first.
Yes, LOI, yes, sir.
So have you made an application for LOI?
No, not yet.
Before the Director of Medical Education. However, it is important to note that obtaining the LOI does not guarantee the subsequent issue of letter of permission by the government of Assam. Second matter, the institute can then make necessary arrangement for physical infrastructure and clinical facilities, including the availability of qualified human resources as per the norms set by the respective councils. Well, in this regard, I will humbly submit, well, they are already functioning. Probably they will have to have that infrastructure. It's not that they are going to open a new institute. So these things are already there with them. And if they are running it without this infrastructure, then in that case, what they should be such. That's my understanding. They will have to have the infrastructure.
So first of all, they have to have a LOI.
LOI. Then, my lord, they will go for inspection.
Then they will go for inspection. After inspection will be the LOP.
NOC.
LOP.
Yes, the medical and that. Should be the before the government.
Then after the LOP,
There is
for
provision
affiliation.
NOC
Then, my lord, the affiliation at 7.
and NOC and
There is no
thereafter
NOC. There is no NOC. Letter of permission is there.
No, my lord, 5.
5.
The institute having
Okay,
LLC
no
from the
objection.
government shall obtain an order certificate form to for admission in the very new academic
Then
session,
affiliation.
then affiliation.
thereafter affiliation from
Comfortable.
university.
You have got affiliation with the university.
Yes.
Correct.
My lord?
You have got affiliation with the university.
No,
You don't even have that. So
I have been
what have
maintaining-
you got? You have got nothing right now. Because you say that you do not come within this framework.
I am just running a professional training course under National Skill Development Corporation. It's a kind of vocational training. My lord, if you permit,
Then I think, then look, there is one thing. Before going into the merits, you have to take a stand as to whether you are going to ask for the LOI, LOP under the framework. If you say that you are not going to apply, then we will decide this case on merits. If you are saying that you are going to apply as per the framework, then we can decide on your application and give you time to make the necessary application. So you have got to decide whether you are going to apply under the framework or not going to apply. If you are going to, if you say that no, framework does not apply to me, then I will decide this case on merit.
okay, my lord, I will obtain instruction that whether the client still wants to remain under professional training or he wants to switch over to this framework.
Ha.
On second or after Bihu, it can be
Maybe on second. Because giving over after. Only on that point, my lord, it can be addressed close or we'll.
Only on that point.
Only.
Okay, right.
Okay.
The Mr. B.R. Sharma, learned counsel for the third, Mr. B.R. Sharma, learned counsel for the petition, Mr. P. Gogoi, learned counsel for the health department.
My lord, I appear as additional agent now.
Acha. Okay, congratulations. Yes. And the additional lady, huh? The petitioner's counsel shall obtain instructions as to whether the petitioners are going to are going to obtain the necessary permissions under the regulatory framework of the nursing, pharmacy and allied health science sectors in the state of Assam, as provided under the notification dated 7/11/23, page 21, huh? Or whether the stand of the petitioners is that they are not covered by the above notification. And Mr. B. Gogoi, the additional AG shall obtain instructions as to whether as to the time that is to be given to the respondents for considering the application of the petitioner for deciding their application in terms of the notification, in the event the petitioners take a stand that they are covered by the said notification.
Right.
Place the matter on second.
Right.
We have filed an affidavit with that also record.
Who has filed affidavit?
We have filed
By the
Yes.
number two lordship.
Just a minute.
Lordship.
Just a minute.
that is not on record.
It's okay.
Definitely, no copy.
Yes, let us see your affidavit.
I also don't have the copy. Because
We'll both use this. So what is your affidavit?
Lordship, they have made an attempt to prepare some document, lordship.
They have not decided.
No inquiry, nothing, lordship. May kindly have a look. Affidavit, sir.
Yes. Sarah,
Lordship, in the annexure structure.
annexure. Yeah.
Lordship, page 77, lordship.
Yes.
Page 77. This is a document, lordship, by which the sub-inspector of school visited, allegedly visited the school, lordship, and obtained a statement of CRCC and headmaster that the managing committee was not constituted as per guidelines. But the very CRCC and headmaster, they were heard, and after hearing them only, the SMC of the petitioner was approved by the DO, lordship.
From where do you say that? How do you say that?
Lordship, we have annexed the document, lordship. Lordship, page 48 may kindly be seen.
Page 40?
48, lordship.
Yes.
48, lordship will say, the Golok Elementary Education Officer, Golokon, number 2, CRCC concerned, number 3, the headmaster, so-and-so, Sukita LP School. After hearing them,
Page 48.
page 48, lordship.
After regarding hearing in connection
Hearing,
with.
yes,
Ah.
on a complaint
Ah.
filed by Shahalam Bepari and others
Against the SMC office.
against the SMC. And lordship will say 49 is the approval of the SMC.
Page 49.
49, annex 6. Headmaster duly forwarded all the documents as per prescribed format.
Okay, this document that they have submitted in their affidavit.
Lordship, actually, lordship, page 69 for a moment.
69.
I'll be page 69. This is the interim order, lordship.
Yes.
Now, in continuation of the office order number so dated 23rd February 2024. Now, lordship will kindly have a look, page 67. This is the order 67 annex 12.
Yes.
Lordship will get memo number so-and-so
Yes,
dated 23/2/2024. In continuation of this order, the interim order has been put. Where from these things come, lordship? There is no reference, nothing. They have simply manufactured the things as per
In
instructions of
continuation of the office order, so the term of ad
ad hoc committee.
this is what
Where extended, lordship.
as per office is constituted with the following members. As per office order, so ad hoc committee is constituted with the following members, 3 months. So it is constituted for 3 months, then page 69.
For 3 months, thereafter, there's no proof, nothing. And suddenly, lordship, page 69 order.
3 months, 23 to 24. And this is after, okay. This is in October.
Lordship. October, the interim order passed directing the PO to reconstitute the managing committee without dissolving our committee, lord. There is no communication, dissolving, no order. In this connection, lordship, we have.
Where is the reconstitution allowed? Where does it say that?
Lordship,
Where does it say that The SMC has to be reconstituted.
Page 27 is the guidelines we have annexed. Page 27.
Oh, in page 69, where is it? It's not
Look,
there.
page
What are you talking about?
Serial number 4.
You're jumping from one page to the other without connecting the dot.
Sir.
Page 27, what?
Page 27 is the guideline.
So what do you want to show me? Which
I
page?
want to show that before reconstitutional committee, the district elementary education has to initiate an inquiry. And after
Where?
the page 27, Roman number 5. Sir.
Page 27.
Sorry, I'm page 29.
29?
29. A lot of people will get dissolution of essence.
Yes.
Serial number Roman 3. Sir.
Roman 3. Yes.
May I read, Lordship?
Yes.
While receiving complaints against the SMC from community organization government so regarding non-compliance of government order, instruction, negligence of duties and responsibility, non-cooperative of implementation government funded scheme for the improvement of the school, the district elementary education officer will initiate, institute an inquiry into the matter and subject to the authenticity of the complaint shall pass a reasoned order for dissolution of the SMC concern.
So where is the complaint on the basis of which a ad hoc has been made?
Lordship, complaint we have also annexed. That is page 53. 57. Lordship. Annexure A. This is the complaint.
Yes.
This is the complaint made by the same person who earlier also made a complaint, and after hearing all the concern, the DO approved our committee. That person again came with the same sort of complaint.
Now, on the basis of this complaint,
That's it.
your SMC has been suspended.
Captain in abeyance.
Abeyance, where is that?
That's it, page 60.
Where is the inquiry report?
The affidavit, I think, for
Huh?
The affidavit filed by the respondent number 2.
Respondent number 2?
Let's keep holding that one.
This is you.
Nice.
Submission of inquiry and visit report of 699. This is dated, what is this date? 16/9/24. No, this is different.
Of this affidavit.
Huh?
I'm not having the copy of the affidavit. But the contents of the affidavit can be seen below. There are 3 annexes annexed. One is the inquiry report dated 20/09/2024. Application of the head teacher dated 16/9/2024 and 18/9/2024.
Is not constituted as per guideline? What guideline? Both the party were demand to meet,
They have
not
never-
constituted as per guideline. The early SMC is not constituted as per government proper guidelines. Both the party were demand to newly formation of a. How do you say that it was not formed as per guidelines?
So that is this is subject to the hearing that was taken place. Because this CRC.
No, you have got to clarify. How is it like, you see, how can you say that the constitution of the SMC was not due, was not proper? or was against the government guidelines. Which guideline? Guideline number 1, 2, 3, 20, 2005, what? Which number?
Well-
You cannot just say that you are guilty of the IPC or you have committed the offense under the IPC. Which offense?
Well-
You've got to clarify. You cannot give such a vague.
Be taken about Tuesday, my lord. Let my copy of the affidavit. I don't have the copy of the affidavit. I don't know even what's the inquiry. So in fact,
There's
I
nothing
asked
here.
my friend today because I did not find the affidavit in the record. I asked my friend whether it, in the official WhatsApp site, it was shown that an vetting affidavit has been sent to S to Tia. I also asked him a copy of that affidavit so that I can be prepared before the matter is called.
There is nothing in the
Can it be
record.
taken up next week, my lord? I can get this.
Okay, right. So have you filed it or what?
Yes, it is filed on 25th.
Okay, Mr. B. Kaushik, Learned Counsel for the
Elementary.
Elementary Education Department submits that affidavit in a position has been filed by the respondent number
2.
2. However, the same is not on record. Registry to list the same. However, to place the same on record. Full stop. The matter pertains to the SMC of 699 Uchika LP School, which was constituted on 5/1/2024, being kept in abeyance by the impugned order dated 21/2/2024. It is the case of the respondent that the SMC has not been constituted as per the guidelines. In terms of the inquiry made by the respondent on which day?
18, Lord.
When do you get 18?
18 September, Lordship, the Sub Inspector of School visited page 78.
Where is the date? There's no date.
Lordship, may I kindly have a look, page 77, Lordship. 2, the Pollock Elementary Education on 18 September, he has returned to the Pollock Elementary Education.
18th, okay. No, so
There is no date of inspection.
then that's what I want. Dated nil. Full stop. The Mr. B. Kaushik shall specify as to which provision of the which specific term and condition of the guideline has been violated. This is a matter on 7.
But there is an interim order that
Interim order to continue till the next week.
if you have to guide.
Right. Right. Miss S. Khalifa, S.A. Khalifa, Learned Counsel for the petitioner, placed for adjournment. On what ground? What personal difficulty? Whose personal difficulty? Huh? What difficulty? Which court is she in? She left the court. She came, but she left before attending to her case. Placed for adjournment on the ground that her senior has left the court premises. Stop. The petitioner is agreed by the rejection of the application for compassionate appointment by the SLC on the ground that the application was not submitted within 1 year from the date of death of the petitioner's father.
The petition reported within 1 year.
Stop.
But the petitioner filed it for the
We do not know. That's a question of fact. You can say anything, they can say anything. Now I will have to decide the issue depending upon who is more smarter. So you both have to be dressed up properly, smartly, and then I will decide. Can it be like that? It cannot be. Or you see, what I'm trying to say is, because you say something, that does not mean that it is the gospel truth. What she says also might not be the gospel truth. So whether you're smarter or you're smarter doesn't make a difference. We have to see now, how do we decide what is correct? How? How does this court decide whether you're telling the truth or she's telling the truth? You're right. In this regard, Ms. R.B. Bora, the learned counsel for the BTC, has submitted a letter dated 21/3/2025, which is to the effect that there was no record of the application for compassionate appointment submitted by the petitioner within 1 year from the date of death of his father. The matter appears to be a disputed question of fact. However, in view of the prayer made by the petitioner's counsel, this is the matter after review. Just think about it. How do I decide this case? Supposing you are the judge, and
we have
but they have also submitted a letter saying that we do not have any record prior to 1 year, being prior to the lapse of 1 year. So what to do? Who do I? Even they've got a letter. You have got your own application. Now who to believe? Think about it. Next.
Okay. Lordship, as per order of the 26th of March for the 25 Lordship. Lordship services awaited in response 120. That's the
Querying on behalf of Mr. FMC system. Do we have an instructor with possibly will be able to place the compliance of the next time?
Next Friday. Okay, right. Mr. P. Kaushik submits that he is appearing for Mr. SMT Kishti, learned counsel for
Response number 1.
response number 1. He submits that compliance report will most probably be made by 4/4. This is the matter on 4/4.
Lordship in item number.
All same order, one order.
Item numbers 37 and 38, Lordship, service awaited for all the respondents, 158.
Here all, it doesn't matter. They are. This is. From 30 to 41, except for 31.
For finance department.
How can it be for finance? There is a contempt. For commissioner secretary, we can say, but not for finance department. Mr. A. Chaliha submits that he will be appearing for the respondent number 4. What do you want now?
Not, that's why
Huh?
petition may kindly be considered.
How?
First lot your October.
I cannot consider just like that. You have got to how does your case come within the provisions for review?
Fine.
You've got to show that. Now,
My lord,
you filed this writ petition, correct?
my lord,
Where is the order page?
my lord, page number 5250.
250. 250. What is this?
Just my lord, in paragraph 10, page number 53, my lord.
Just a minute. Let me turn the page. 250.
Fine.
Okay. 250.
Yes.
250 is
Oh, sir, I'm sorry, my lord, it is 267. 267.
267.
Transfer section. Paragraph 9 and 10 of the
Then after that you went to the division bench.
because it's subsequently, my lord, I obtained some instruction with regard to that particular doctor who is.
Writ appeal is dismissed on withdrawal with liberty as a with liberty to file an appropriate application. You file an appropriate application. Where is the question of review?
Because my lord, your particular to take my care.
Huh?
The fact that the particular doctor who rendered the opinion was written in a fair case. Which
With the
was the opinion was rendered in a page without any seal and signature. And the designation of the doctor was
correct.
clear.
Correct.
So to that effect, my lord, I approached the authority in the same case. The authority should put and certificate your not.
Okay, subsequent to my order,
My
you have gone again to the
my lord,
GMCH.
Fine.
So where is the question of review?
But my lord, that particular doctor was the part of the RNA. He was the part of the review medical examination who rendered the opinion.
Where is it? Page
My lord, page number 12.
12.
Page number 12. 1.
To Mr. Arfan Ali, advocate. This
Fine.
one.
Fine.
Huh?
One notice was sent to the authority, seeking some explanation as to the name and designation as well as the qualification, as that was the query of the honorable court with regard to the opinion.
Right. Right. Heard Mr.
Yeah.
A. Ali, Learned Counsel for the petition. Also heard Ms. B. Sharp. Anything to say about?
Lordship, no, but in writ appeal, I have filed my affidavit. That is, they have not annexed that with this review petition. And so far, this review is a review of lordship order in a writ petition, but this is filed as a under CPC,
Which one?
under the Code of Civil Procedure.
Ah, it's okay. Well, I'm dismissing your review petition. Okay. Right, Mr. A. Ali, Learned Counsel for the petition. To submit that the impugned order dated 29/11/23 passed in WPC 6839/2026 should be reviewed inasmuch as the petitioner had sought a clarification from the page from the
Superintendent,
from the office of the superintendent, Guwahati Medical College and Hospital, bracket GMCA, as to the qualification of Dr. A. Mahanta, who had issued a medical certificate to the petitioner. He submits that the clarification had been sought for while letter dated. Where is when did you seek the clarification? While pleader notice dated nil. The same was replied to by the Department of Neurology, no, Professor and Head in Charge, Department of Neurology, GMCNH, on 16/2/2024, that is after the judgment and order dated 29/11/23 passed in WPC 6839/23, stating that Dr. A. Mahanta was an assistant professor of neurology in the GMC. Yes, sir. The petitioner's counsel submits that in view of the clarification made by the GMCA on on 16/2/2024 with regard to the fact that Dr. A. Mahanta was a medical doctor, the contents of the finding of this court in para 10 of the order dated 29/11/23 passed in WPC 6839/2023 should be satisfied. Next one. Ms. P. Sharma, learned TGC, on the other hand, submits that no grounds for review has been made up. And why did they withdraw before the appellate court? They said they will go in the review. You were there also.
Yes, but I was there. I have filed my affidavit and.
So what they asked for? They asked for withdrawal of the writ appeal.
The court directed that you should file appropriate application. That is
Okay.
what
Okay, before this court.
court
directives was not when the particular court was brought into the case of the unrestricted test court, then the test was that's fine. Yeah, for that.
Whatever I said. And as such, the review petition should be dismissed. He also submits that. No, that's yes, sir. I have heard the learned counsel for the part. As can be seen from the order dated 29/11/23 passed in WPC 6839/2020. The writ petition had been dismissed not only on the issue of there being no clarification as to whether Dr. Mahanta was an MBS doctor or otherwise, comma, the writ petition had also been dismissed on the ground that the petitioner had tried to make out a case that two different review medical examinations had been held on 2/8/23 and 5/8/23. Though it was actually only one review medical examination held on 2/8/23, wherein the petitioner was found to be unfit. It was in view of the above reason. It was in view of the above reason that this court had reproduced the law laid down by the Supreme Court in K.D. Sharma versus Steel Authority of India Limited and others, reported in 2008, 12 SEC 481, wherein the apex court had held that the party who invoked the extraordinary jurisdiction of the court under Article 226 of the Constitution of India is supposed to be truthful, frank and open. He must disclose all material facts without reservation, even if it is against him. He cannot be allowed to play hide and seek, hide and seek, S-E-E-K, hide and seek, or to pick and choose facts. Full stop. Further, the petitioner's medical condition had been declared to be unfit not only by the medical examination held on 31/7/2023, he was also found to be unfit by They are also found to be unfit in the review medical examination, which had been held on 2/8/2020. On considering the above, fact, this court is of the view that the review petition cannot be allowed only on the ground that there had been some clarification with regard to whether Dr. A. Mahanta was a MBBS doctor or not. The other fact of the petitioner trying to mislead the court with regard to the issue of 2 review medical examinations being held, having found to be false. This court does not find any ground to allow the present review petition. The review petition is accordingly dismissed.
Closing my thought. With regard to the subsection of that, like, paragraph 30.
This is not a, just you write something. In the case of so, the Supreme Court has held that a review petition cannot partake the character of an appeal. As such, this court is not inclined to go into the other aspects thought to be raised, the other aspects of the other aspects of this case, which have already been decided by.
43 and 44 for years.
Just a minute. So where is the post-based roster? Where is the roster? You have only said that it has been prepared. It's like saying you have prepared the omelette. Please let us have the omelette now. Only should. We want to have it. Oh.
What extent, Professor?
In the council, this does not say anything. Where is the huh?
Definitely to see.
Huh?
Next page.
Okay, next page, yes.
First, biotechnology.
First post.
Yes, sir.
We'll go to whom?
No. See, there are 5 sanctions things. Out of the already advertised SC and the one which is going to be right. We have in 23.
Mr. Council, I do not know whether this is how they make a post-based roster.
The note is very clear because
Is this? It has to be
year.
number 1, 2, 3, 4, 5, 6, 7. That is
not please go to the note. Everything is clarified by the registrar. In the note I submitted before a lot.
If I may submit, that's if his
That is
affidavit
the
is
ideal
apparently and palpably clear, he says we are not following
correct. There's nothing here. There's nothing here.
It is not that, Lordship. We
Yeah.
are trying
If we are, look, I was expecting you to be more. I don't know. To help me understand. You are not helping me understand at all.
No, definitely to see.
And I think I'm an average IQ I've got. So if I've got an average IQ, either this thing is way above my head, or I do not know. Because when you say post-based roster, what do you mean by post-based roster? Supposing the first post is there, it will go to whom? It will go to whom? Will it go to a reserved category? Will it go to a unreserved category?
That is part.
Whether it will go to a SC, ST, Who will it go to? That is how you make a post-based roster. Now, this chart that you're showing me does not say anything. It just says that serial number 1 department by the sanction state. Okay, sanction state. Now,
Please to see the column.
huh?
First column is department, second is section strength, then
Man in
man in
position.
position.
Yes.
Those are the points.
Now, where are the roster points? In a roster point, say there is 100
Point.
100 posts. 100 posts
Yes,
are there.
yes, sir.
If there are 100 vacant posts, created posts, supposing it's a new department, you're going to fill up those 100 posts. Now, how are you going to fill up by applying the reservation policy? How are you going to fill up? Just give me an idea.
It was a notification as per the table space. We have to maintain the percentage by.
Correct.
That
How
we
are you going to?
We are,
And if it's going to be post-based, how are you going
no,
to?
we are calculating as the university is a whole. And lordship, we are maintaining that reservation, suppose for SC is 16%. We are maintaining that. Sir.
Because answer. How are you maintaining it? Now this sanction strength is how much altogether? 258.
250.
Now if there's 258, show me post number 1 will go to whom? You tell me, according to your post-based roster, post number 1 will go to whom? Who was it given to? Who was it given to? Because you already the department is functioning.
Yes, sir.
So that post number 1 has been given to whom? Reserve category, unreserved category, or to whom?
But the demonstration is clear in the office memorandum at page 129. Entire 200-point roster has been shown. This has to read page 129, Lord, for direct system.
You have to make me understand. I'm trying to understand, but difficult.
But
Yes,
page
200 and
129 for my Lord.
129. Yes.
This is the logic that has to follow in a post-based law. So they will have to clarify fifth point. We are giving an open competition. We are opening an open competition. Person has to fight for this. So fifth post is it for a reserve category, he will be allowed to fit for that. If it's a sixth post, it
No, I saw one advertisement also. It was written 19 unreserved. Something like that.
Right.
So that post,
that
the
goes to
number.
show that it is for an answer.
Yes. So that you could compare that with the point.
Lordship, page
Post it. Page
123.
Page?
Page 123.
Yes.
Similarly, we are following this.
Agreed.
Yes, and
No. You are following a post-based roster, correct?
yes, sir. And this
Now
is the
you
chart.
come to page 129.
Yes, Lordship. Yes,
You are following this.
yes, Lordship.
This
We
is
are following that.
But
If
it's a
it is there,
vacancy
Lordship,
based.
petitioner may.
And Willards,
No, Lordship.
Willards will see their averment in the affidavit,
No, Lordship.
specifically and palpably clear, they are following the post vacancy.
Lordship may.
How can he say that we are following the
Lordship may
rules?
do one thing. Ask the petitioner to visit the office of the registrar and examine
I
the
don't
entire.
have any business.
No, no.
to
Then
do that.
examine.
No,
When
no,
is the-
Mr. Kausal, please show me your post-based roster. Show me your post-based roster.
Lordship, the note of the registrar is very clear.
Look, this page 129 is not your post-based roster because it is only a model. It is only a model.
It is model law.
It is a model.
Yes, Lord.
And it is a model for how many posts? 200 posts.
200
No,
posts.
not even how much, for 200 posts.
Yes.
Your sanction strength is for 258.
50.
250.
They can
Now,
increase and
or
decrease
it
that.
can, initially it might have been 100 also, maybe 150 also, we don't know.
There is a.
So show me your post-based roster.
Lordship, because Assam University is not reached to that point of roster. For the vacant,
Since
we are
1997,
maintaining.
this roster has been followed throughout the country. From the
No,
1997, if 200%
No,
haven't
it
been
is.
appointed or had retired.
Lordship,
But this gives an absolute, totally lot.
no, it is there.
But that was the reason they completely violated my lord's order. That when it was set aside, they again went for the same recruitment process.
We have not piloted any.
The entire
petition
case
of
was
this
hinging on this. But
Only petitioner saying they will not do.
When we'll call a registrar, let him bring
But-
let him bring the post-based roster.
But-
You are not trying to understand.
Yes, Lordship, we'll produce everything.
We'll tell you
If
register
required,
to
we'll,
produce. You see, we don't want everything. We just want the post-based roster. That's all. Show me the post-based roster.
because the university has not reached to the ideal situation.
Mr. Counsel, look, whether ideal or not ideal, that's not the
Because we
issue.
are following the, this.
Look, your letter
Yes, sir.
has said that has prepared post-based roster, which has been duly approved by the Executive Council.
Yes, sir.
Now you have prepared it. Please show me.
I've even looked at that.
It's like saying, yes, I have prepared one aloo paratha at home. Please give it to me.
Lordship had supplied the bunch of the paper. Which, as per this notification, we have prepared this notification. And Lordship, one expert from the university came and he approved it.
Yeah, just running around the bush. No need. Right.
And Lordship set aside the entire roster that we have not taken.
I am not setting aside anything. I am going to ask the registrar to show me.
To be satisfied because Lord.
No, it's not the petitioner. Even this court has to be satisfied that you have prepared a roster because you have said that you have prepared a post-based roster. If you have prepared a post-based roster, bring it to me.
Lordship, this is a submitted before Lord.
Which one? That is not a post-based roster. This is not a post-based roster as per the model.
No,
The model, you see, the model has to be followed. You cannot make your own model, which is not understandable by anybody.
Lordship, we have given clarification that the registrar that submitted before Lordship.
Their affidavit at page
No, if
343.
If you say that is your post-based roster, then you show me as to the vacant position now. Where does it come?
Which point?
In which point does it come?
Which point they have
Yes.
advertised that?
We have expected that the university has been considered one unit. And we are maintaining
Point
the,
is-
Maybe one unit, but show me in that one unit. Okay, forget about department-wise. Where does reserve category come? Where does unreserved category come?
we are calculating on the basis of percentage. Filled by the,
Percentage will agree, always follow.
Madam?
Plot.
Correct. Correct.
then Lordship,
We are trying to confuse only. I didn't expect this of you, Mr.
then Lordship may do one thing. Lordship set aside the entire process, the advertisement, and director to prepare roster as per this point-based roster. That will be.
They have to do that. Basically, so you don't have anything besides this.
Yes, sir.
So that your document here. Yeah, where is that document that you were produced? You were relying upon? What was that? Page?
360.
Separate document.
But the document which they have relied in the affidavit is at page 365, annex 7. Which is
Which?
Lordship,
This is the one. This is the one, no?
this one.
This is, you are relying upon this.
Yes, sir.
This is not a post-based roster. Even
Then Lordship,
I, with my limited knowledge of this roster point, I am not convinced at all.
then the direction may be to the university to done away with all this process and they.
Correct. They should make. They should make.
Yes,
has to be in
then-
97 office.
then
member. RK server was says 97 office member. That has to be followed throughout the country. They will have to follow that rule.
That page 129.
And that is 1997 law.
No,
That is
page 129. No?
Yes,
Lordships.
we are relying on this.
This page 123 onwards.
123 onwards.
So this,
Give
so,
direction to
makes
a-
a
as
mention.
per this model, you have got to make.
Yes, Lordship, then it
Yeah.
request will be disposed of the direct university to follow this and
That has
as per
to be
the post-based roster. We'll follow that.
Why did you take any dictation? No, let him take. It's okay. You go. You go. You've got a train to catch also.
That the advertisement has to be quiet.
Yes, Lordship, everything may be quiet.
Advertisement,
Naturally.
Yes, definitely.
that will be the fallout of this.
Right. Third,
Lordship,
Mr.
specific direction will be given the university to follow this notification.
Yes, as per the 97.
Yes.
Till then the
But till then, the rule be made absolute, but they should not proceed with the advertisement until.
Actually, everything will go.
Advertisement is cancelled.
Everything will go, but unless they can identify
And last 2
which point is to be filled up, how will they fill up?
For last 2 years, we are not filling up any post. But the student is suffering.
So they will, no, that's okay.
Yes.
In that case, Lord, if I may pray, but it's subject to my Lord, that if brushing aside the advertisement, they should apply for the leave of the court after supplying the roster point that they had made it out. Because Lordship, now Lordship, this got the Supreme Court judge, but it has to be subject. Supreme Court, but that matter was for the Allahabad High Court. They prayed that will have to make subject wise. Supreme Court says that has to be subject wise in those cases because in cases that might be a situation but certain posts will entirely go to the reserve category or entirely to the number of unreserved categories. So that case, Lordship, Supreme Court said that at the cases, depending upon the fact, subject wise is also permits the Lordship that.
Lordship, in this case, there will be difficulty. Suppose in recruitment department, there are 5 posts. If 5 posts goes to the unreserved category or reserved category, then how department will function?
No, that is why, that is why.
Yes, Lordship.
But then you have got to make a point-based roster anyway. A point-based roster is not here.
And we'll follow this notification of 2nd July 1997.
You have to follow.
Yes, Lordship.
Where is that?
Lordship, get the, I'll just give the condition.
Okay.
That is a 2019, that is you earlier.
I hope it's not overruled or anything. Not deficient.
But as if I may read, Lordship, for my Lord, and
UGC.
Then the rule, the act, what will be the
that has been
separate
discussed
rule?
in this case, has been discussed in this.
Notification.
We'll just say that let it be decided. Let the issue whether it's subject wise or we won't go into that.
Yes,
Let the university decide.
Yes, Lord. Yes, it is
Correct.
there, Lord.
Otherwise, we are going to might cause trouble. We
Yes,
might
okay,
cause
take-
more trouble.
take-
Yes.
Let's take it.
Heard, Mister. Yesterday's order. Para 1 same, para 2 same, para 3 same, para 4 same. I think para 5, still para 5, huh? Then para 6. Mr. S.C.K.L., Learned Counsel for the Assam University, has submitted a letter dated 28/3/2025 issued by the registrar of the Assam University, which is to the effect that the university has prepared post-based roster, which has been duly approved by the Executive Council of the university, and the same has been uploaded in the website. The letter also states that the rosters consider the university as a single unit and that they had not prepared the roster departmental wise, as it was contrary to law. In this regard, the Mr. S.C.K.L. has also shown this court. Has also, what is this? What is this? This thick piece of paper? Has also submitted a chart showing the sanction strength of assistant professor to be 258, while the man in position is 226. The vacancy position is 32 and the current vacancy is 27. He submits that the said chart is a post-based roster point made in terms of the
Memorandum dated 2nd July 1990.
made in terms of the office memorandum dated 2nd July 1997, issued by the Government of India, Ministry of Personnel, Public Grievances and Pensions, Department of Personnel and Training, in pursuance to the judgment of the Supreme Court in the case of R.K. Sabarwal versus State of Punjab. Supra. Then anything else? No.
But there is one contempt petition connected with the issue. And that was people that happened.
Has that been, has any appointments been made on the basis of the, huh?
We have filed our application.
But if their affidavit, page 51 of the contempt, specifically admitting that accordingly the Assam University has advertised the vacancy. That was the speaker, not to proceed with that.
Not if that was with that the vacancy was the earlier vacancy, 6 vacancies there.
Entire thing was wrong.
No, you see, when the advertisement has been stayed, you cannot act, whether it is the earlier or not, whether it is, if it is within that advertisement, then you cannot do it.
No, that was a separate advertisement.
Specifically, they have spelled it up. We have
Huh?
done that.
Then Lord said, hear that matter. Lord. You
Contempt, I will hear you, contempt here, contempt, I will hear you.
Yes, that may be kept. Yes, Lord.
But only thing I want to know is, has any appointments been made subject to that advertisement? Huh? No. You see, issuing of advertisement is different. Has there been any appointment pursuant to that advertisement? Selection process? That is what I'm asking. Because if only advertisement has been issued and no appointment has been made, then okay, it's redeemable. Just a minute. Yes, what, You see, that is the small issue, whether appointments have been made or not.
It's not there.
Huh?
No appointment has been.
For my lord's consideration at page number 45 of the contempt petition, the council perused and approved the 4 persons have been selected. They have approved them. After advertisement, that is
Has they been appointed?
Lordship has been appointed. Selection and appointment of faculty against the employment notification of 9/10/2020. 4 names, chairperson placed before the council. The recommendation of the selection committee are detailed below. Down below, the council perused and approved the thing. Also has to contempt like for my.
And Lord, that was the interim order.
In the Lordship, what?
Either you submit or I.
Okay, you complete.
You complete your part.
So,
Lord, to me, here the contempt petition separate. It's a contempt, Lordship, I start including the PC may be fun.
naturally,
Yes, Lord. So the fact should be clear before your Lordship.
correct.
Only making that we have committed contempt.
You see, one thing is there. The interim order says what? That you cannot, what does the interim order say?
Status quo should be maintained.
Status quo should be maintained. When was the date status quo should be maintained?
27/9/2023.
27/9/23.
Yes, Lord.
Status quo. Then the selection was made when?
Lordship will have a page number 45, that is 9/10/2020.
9/10/23.
2020. 20.
Selection.
Just a month back.
No, not month back. Month after that.
Month after 27,
So 9/10/23. Then approval given on
on the same day.
approval, selection and approval.
Selection approval on.
Then
29,
appointment,
20.
appointment,
Appointment council perused and approved the same.
Huh?
9/10/23, the council said selected 2 persons and then approved on the same. Lordship will have each 40.
so appointment orders issued or not?
Orders, Lordship, here is not mentioned.
That's
That-
what I want.
Approval and.
Approval is a different thing. Why are you trying to confuse? Please understand the question. Please do not push only your agenda. Okay,
is there.
we want to know the truth.
Correct.
So there are certain queries that I ask, which are specific in nature. Don't gloss over that. When I say appointment, it does not mean approval.
Okay.
Okay, there's a difference between approval and appointment. So when I ask you about appointment, don't say that approves this. So is there any appointment order? That you don't know. Say that.
Not there.
So no, I do not know. Whatever it is, you have also disobeyed the orders of the court. That is clear.
Yes.
Only so we will see. But are you please get information as to whether there was any appointment orders issued?
I'll clarify it.
Yes.
What?
You bring that on the next day.
Yes.
So where are we? Okay, Sabarwas. I have heard the learned counsel for the part. A perusal of the though the letter dated 28/3/2025 issued by the registrar of the Assam University states that a post-based roster has been prepared by the university, which has been uploaded in the website. The document which has been submitted, the documents which have the chart which has been submitted by the by the council for the university regarding the sanction strength, etc. of assistant professor goes to show that the same cannot be said to be a post-based roster point made in terms of the poem dated. Huh?
2nd July 1990.
Poem dated 2/7/1997. The poem dated so clearly provides the model roster form for reservation with reference to post for direct recruitment on an all India basis to be followed by the state government in cases of appointment by direct recruitment. The same has been based upon the Constitution bench judgment of the Supreme Court in the case of R.K. Sabarwal. The chart produced by the Council for the Assam University not having been made in terms of the model roster as provided in the OM dated 2/7/1997. It is clear that the attempt by the state respondents to appoint assistant professor in the various subjects, including biotechnology in biotechnology is not in consonance, is not in consonance with the law laid down by the Supreme Court in R.K. Sabarwal Supra and the OM dated session. In view of the above reason, the Assam University is directed to make a post-based roster point in terms of the OM dated session at the earliest. Thereafter, the appointments to the various posts, appointments to the various posts of assistant professor. In terms of, it should be made by way of a fresh advertisement by specifying the roster points against which the new appointments are to be made. That's all. Consequently, the advertisement number 3/2023 dated 6/7/23 issued by the Registrar Assam University hereby set aside.
Point of dereservation in terms of fulfilled part. That
Huh?
is not dereservation in terms of fulfilled part.
Unless and until, no, unless appointments had already been made prior to the status quo order dated 12/9/2020. So, if any order, if prior to the status quo order, the appointment had been made, then it's okay. Okay. That's all. The writ petitions accordingly disposed of. Anything, madam? That's okay, no?
Petition may be listed after month.
Huh?
There is a contempt file.
Right, in the contempt petition. This heard Mr.
H. Bitala.
H. Betala, learned counsel for the petitioner, who submits that the petitioner had put to challenge the advertisement dated so and so for direct appointment to the post of assistant professor biotechnology which included appointment to the post of assistant professor biotechnology, on the ground that a post-based roster point had not been made by the Assam University in terms of the judgment of the Supreme Court in our case Sabharwal versus Union of India. Reported in State of Punjab, reported in 1995, 2 SCC 745. He submits. No, he submits that a status quo order has been passed on 12/9/2023 against the advertisement dated. The advertisement number 3/23 dated 6/7/27. However, despite the same, the respondents have selected and approved candidates on 9/10/2023 in person to the advertisement. He however does not know whether appointment orders have been issued against those selected and approved candidates. Next para. Mr. S.C. Kar, learned counsel appearing for the respondents. Huh? For the respondent submits that he will obtain instructions as to whether any appointments had been made after the status quo order dated 27/9/23, in pursuance to the advertisement dated, the advertisement number 3/23 dated 6/7/23.
Yes. We have already filed our affidavit also in the contempt of order.
12/9/23?
23.
What, which order?
This order where the contempt was, but status court.
Status quo order is,
12/9/23.
didn't I see that?
Lordship, that's well, if I have correctly heard, it was 23.
Okay, 12/9/23, that is right. 12/9/23, correct.
Lordship, we have already filed our affidavit in contempt.
Maybe, but have you said that they have been appointed?
Nothing is.
Then, that's what I want.
We have explained, that may be considered deciding the.
No, you also, I want to know
We'll
whether there is
We'll
appointment.
produce everything, Lord.
I don't want everything. I just want to know whether they have been appointed or
We'll
not.
produce as per direction of the Honorable.
Yes, so I have recorded. Yes, it's the. Oh, that is para 7. Okay, prior to Mr. Para 7, you make it as para 7. In the order, you make it at para 6. Okay, then. Okay, just before Mr. SCK. Contempt, list the matter when?
After due vacation.
Okay, after vacation. This. Okay. The letter dated in the writ petition, the letter dated 28/3/2025 is made a part of the record and marked as Annexure X. Issued by the Registrar, Assam University, is made a part of the record and marked as Annexure X. Today's date is 28/3/25. Anyway, we have got 3 days holiday.
Probably first will also be declared holiday.
Huh?
There is a possibility first will.
We'll know after tomorrow, I
Yes,
think.
sir.
But then we'll have to make up for that on
Yes,
some
sir,
other
on
day.
Saturday.